You all here for our conference on Deep Seabed Mining Disputes. It's a great pleasure for us to organize jointly with the colleagues from University of Kiel, University of Halle and Luther Law Firm this conference, which is on a topic which will probably gain considerable importance in the years to come. For me, it's quite a pleasure to open that, because when I started my academic career, I worked at the Institute of Air and Space Law with Professor Böckstiege. And the first thing I did at the time was he was considering drafting a convention on dispute resolution, proper dispute resolution in the area of air and space law. And at the time, the question was, do we really need that? And he was at the time thought, okay, when we have something like the common heritage of mankind, we have to deal with that. Also, there will be disputes coming, maybe not today, maybe not tomorrow, but in the years to come. And when you look at the very detailed rules already of the United Nations Convention, there was considerable foresight at the side as well. But when you look at the rules, very often they deal primarily with the relationship state-states and not so much just with an annex, state-private parties. But when you look at the developments over the last years, it may actually be that these disputes will be the more important disputes or more frequent disputes. And so for us, it's a great honor and pleasure to have some of the leading people in the area of dispute resolution, in particular in the area of dispute resolution, in these cross-border fields of public international law and private international law here at the conference. With that, I will not steal any more of your time and hand over to my co-organizers that we have a fruitful discussion, and I'm looking forward to that and to all the presentations by the various panels. Thank you very much.
Thank you very much, Stefan. Welcome, welcome. I'd like to welcome you also in the name of Nele, Matz-Lück and Richard Happ. Richard Happ will say a few words in a minute. Nele, Matz-Lück will have the closing word later on. But before that, we are going to work. We are going to discuss, as already mentioned, Deep Seabed Mining Dispute legal issues. If I see it correctly, there is already some writing, academic writing, of course, on the topic, increasing amount of, but there aren't yet so many conferences. We are kind of on the far frontier here for specifically the dispute settlement issues with regard to deep seabed mining. And as most of us probably in this room do believe that we will see in the very near future disputes, I think we are right on time to start discussing that. Without going further into substance, we do that in a minute. I'd like to take the opportunity to say a word of thanks. Thank you very much, first of all, to Bucerius Law School for having us using this wonderful premises here, this wonderful room. Thank you also for the service people with regard to technology. We set up everything so that we are live on YouTube. We have a global audience, so to speak, and presentations and discussions will also be saved and kept on YouTube for those who are not able to make it here today. Also, I'd like to, in the name of all of us, thank the sponsors of this event, and that is namely Luther Law Firm and also Fasken Martineau from Canada. We are very thankful for the financial support for this afternoon. Thank you very much. That's all I want to say at this moment. Let's intensively discuss. Let's listen carefully to the presentation and intensively discuss. And we are very happy to have all of you live on YouTube, but also, of course, here in the room with us this afternoon. Thank you very much.
Yes, good afternoon, everyone. A very warm welcome to our conference here on Deep Seabed Mining Disputes. It's a pleasure to see so many international law experts, practitioners and scholars gathered to delve into one of the most complex and rapidly evolving areas of maritime law. What is this workshop today about? Well, when the United Nations Convention on the Law of the Sea was negotiated and signed back in the 80s, it was clearly a groundbreaking step in codifying the rights and obligations of states for maritime spaces, including the area which holds the common heritage of mankind. At that time, however, modern commercial and investment arbitration was still in its infancy. And the last 42 years have seen an explosive growth in procedural techniques in law and in case law on how arbitration proceedings should be conducted. And that is due to no small extent to the sheer creativity of its practitioners, of law firms, lawyers, arbitrators who have been faced with certain problems and developed solutions for those problems. And this leads us to the question at issue. What happens when a deep seabed mining dispute ends up before skilled and resourceful dispute resolution practitioners who can and will harness all the tools, all the knowledge, all the techniques, and all the insight developed since 1982. Does the original enforcement framework and dispute resolution pathways envisaged in UNCLOS still stand? Or will they be put under the strain of complex, high-value, and politically sensitive disputes? Over the course of today's discussion, we will explore these questions from multiple angles, looking at procedural issues, enforcement challenges, the intersection with sovereign immunity, and how UNCLOS generally fits within the broader landscape of international arbitration and environmental protection. Our aim is to foster a lively exchange of ideas, to spark a debate, and perhaps even to identify pathways to harmonization of developments in arbitration on the one hand, and UNCLOS on the other hand. Once again, thank you everyone, whether you're here in person or currently attend virtually, for joining us. I wish you, all of us, a productive and engaging conference, and I very much look forward to the discussion. Thank you very much.
Thank you very much, Richard. And we immediately go into substance, and we are very much honored and happy to have Professor Rüdiger Wolfrum with us, who will deliver the keynote speech. It's really an honor to have probably the most knowledgeable person on this topic with us. He was in the 1970s very much involved in the negotiating group for Germany of what we are discussing today, that is the United Nations Convention on the Law of the Sea. He was a professor then at the University of Kiel, where, if I may say, I had my very first lecture on public international law with you, Professor Wolfrum, long time ago. Afterwards, he, as you know, switched to Heidelberg, where he became the director of the Max-Planck Institute for public law, comparative public law, and public international law. And he, of course, and that's for us here in Hamburg and this conference most important, was a judge at the International Tribunal for the Law of the Sea and also a president of the tribunal, being a member there until 2017. That's all I want to say. There could be said a lot more things, but I think everybody knows you. We're very honored, as I said, Professor Wolfrum, to have you here. And the speech you are going to deliver is on international courts and tribunals, whether they have legislative competence, interpretation versus legislative foundations. Does it make a difference? We are looking very much forward. Please, you have the floor.
Thank you very much, Mr. Tietje, for your kind words. I remember you you having been in Kiel vividly, then you moved on, but we have met thereafter occasionally. One thing I would like to indicate in the Law of the Sea conference, I was not involved in dispute settlement. The reason was obvious. The dispute settlement was, so to speak, monopolized by certain persons who were perhaps had lots of practical experience, such as Chapter Rosen or Louis Besson or Günther Jenecke from Germany. They formed a small group, and if you dared to make any comments on what they were doing, you were deeply in trouble. My issue is still an issue which was dealing with deep seabed mining. I was the only German representative in the small Nandan group dealing with resource policy, meaning the accommodation in the commodity market, an issue where you are very much involved in, and deep seabed mining. However, you will find absolutely zero legislative history. For such a Nandan had a wonderful system. The first day I participated, he distributed his first draft. And we discussed it, by the way, extremely critically. And then he walked around and we had to return the draft. He put them to one side, and then he came with another draft, which was even worse. And same procedure. And before he could start with the third draft, one member of the group, I believe it was a colleague from the United States, he said, Satya, you are like somebody who is selling vacuum cleaners. Do you want the green or do you want the red one? And then we entered into business, and until the last days of the conference, and if you read the respective provision, you will shake your head and wonder whether you read what it meant, or was it really a workable solution. It's not the task of today, and even I have a problem in explaining this provision. Let me go to my topic. My topic is a bit typically academic. For you could say, who cares whether you say this, what has been happening, what I will be describing, is an act of interpretation. And if you want to qualify it as an act of prescription, so what is the difference? There is a difference, perhaps only a dogmatic one, to explain what has been happening and whether and to what extent subsequent judges or courts are bound by the previous judgments. This is what I will deal with. At the end of this talk, you may tell me, this is academic and practically perhaps not relevant. I would accept that criticism, more or less, I've made. Otherwise, it gives us an insight in the working on this particular issue in Law of the Sea. At this point, I believe it should be mandatory to clarify what is the difference between interpretation and to pronounce new norms. Interpretation means, simply put, to clarify the content of a norm, mostly with the objective to apply that norm. This has been reflected in Article 287, I believe, or 288 of the Convention. Promulgating a norm means to create a legal norm, a new legal norm, The difference seems to be that interpretation requires a norm which may have to be interpreted, whereas a prescription of a norm results in establishing a new norm, which also may be interpreted. Why do I refer to this issue of making that kind of a difference? The dividing line, which sounds so simple, is not that clear. What I mean is to refer to the situation that a legal norm only formulates principles, which international courts are meant to fill with substance. I will refer to Article 73 and 74 and 83, but you could also do the same with the Common Heritage Principle and others. That I leave to somebody else. Is this filling of these two norms, 74 and 83, a matter of interpretation? Please look at Article 73. What does it say? To what extent does it provide guidance for the system of delimitation? If you're honest, not at all. For Article 73 says this may be done via treaties, establishing treaties, and it may be based on adjudication. And then comes the only leading word, but the end has to be an equitable result. The only substantial indication on this system is that the question of equity. Is it enough? What means equity? And if you look into various provisions, starting from the North Sea continental shelf cases to the Gulf of Maine case, to the Black Sea case, or to the most recent case between Nicaragua and Colombia, in this much debated dispute before the ICJ of last year, then you will see that equity can mean a lot of things, and equity requires a lot of issues considered, decisions to be taken. I hope you agree with me that Article 73 and 74 and 83 constitute the basis for the delimitation of exclusive economic zones or continental shelves between opposing parties. As I already indicated, considering the wording of these provisions, it is evident that the preferred approach of UNCLOS is reaching an agreement. This has been mentioned first. And only if that fails, and this is a part which is mostly neglected by international courts, only if this fails, one can go before a court. But the courts check on that, whether an attempt has been made to find a solution by negotiation. If you use the law of the sea treaty, then the reference is always to 282. I will not go into the jurisprudence on 282 or ITLOS, which, by the way, has changed over the period. As indicated by the ICJ in the case maritime delimitation in the Indian Ocean, Somalia versus Kenya, judgment from 21, Article 83 and 74 are, and I quote, of a general nature and do not provide much by way of guidance for the adjudicative institutions or negotiators involved in the marine delimitation exercise. It's an interesting statement, very seldom is being quoted. Practice seems to indicate to reach an equitable result is less problematic for negotiated delimitations than for decided adjudications, decided delimitations. The practice seems to indicate if two or more states freely agree in a delimitation of a continental shelf or in a comprehensive maritime boundary, one should, under ordinary circumstances, assume that the application of the said agreement will meet the demands of equity. Volenti non fit in iuria, if you wish. This is true also for maritime delimitation via conciliation. This is, the reason is rather complicated to explain. I will only show you the result. In the decision between Timor-Leste and Australia, agreement was reached about the Greater Sunrise Regime. That's an oil field or gas field, within which, and I quote, the parties shall jointly exercise their rights as coastal states pursuant to Article 77 of the Convention. Keep that on the tip of your tongue. What is said is actually totally unheard of. How can two states jointly exercise sovereign rights over the same area? We have always learned that sovereignty is excluding anybody else. Nevertheless, the parties agreed to that, and this was proposed by the Conciliation Committee. Why could we do it? We could do it for we had the feeling that we would have to seek a solution, and that every means which brings us closer to a solution would be possible if the two parties so agree. And, sure, with some difficulties, both parties agreed. What is the other particularities? Apart from the joint exercise of coastal state jurisdiction, the delimitation lines for the Greater Sunrise Field may be adjusted or will automatically be adjusted after certain conditions are met. Where did we ever have, okay, let's put it here. Where do we ever have cases where delimitation lines are adjusted or adjust themselves automatically? You will find no other case. The other element, which I will not very much dwell on, is, and this was one of the very important elements, was a question, and this was for Timor-Leste the decisive question, where is the gas to be processed? Timor-Leste said, and I quoted substance, not verbally, we don't want revenues only for 20 years and then are falling back to a developing country with no income. What we want to take this opportunity to become an industrial state. The industry didn't like that approach. Well, I'm not betraying any secrets when I say so. They said these are not even able to produce proper hammers and pots and whatsoever. This is a totally underdeveloped country, which is true. We can go back into the question why this was true. But the leaders of Timor-Leste put their finger in exactly the open wound. all development aid helps for a moment, for 20 years or whatsoever. Hardly ever they produce sustainable installations, sustainable possibilities for the population. Industry was totally against this approach, and you may have not heard about that. Therefore, Timor-Leste purchased from the industrial owners of the Greater Sunrise Field. They existed already, so that I believe Timor-Leste is now 3/5 from the point of private law, the owner of Greater Sunrise. That doesn't change the treaty. The treaty is not on the level of property rights, it's on the level of political rights. Now let me look into the delimitation. If you go through the various judgments by arbitral tribunals, ITLOS, and the ICJ about the delimitation cases, you will see that they have established at the end of the Black Sea case a system what to do. Step 1, step 2, step 3. Relevant circumstances can, according to the common opinion in the courts, only of a geographical nature. We have 1 or 2 attempts to introduce other elements in the relevant circumstances according to which the provisional equidistance line is being adjusted. It has not been accepted security, it has not been accepted fisheries, although this has been proposed, and it has not been accepted, was particularly interesting in the Ghana-Côte d'Ivoire case, so to speak, solidarity argument from Côte d'Ivoire. Côte d'Ivoire argued that the oil and gas was taken from one particular field which belonged to the Côte d'Ivoire continental shelf as well as to the Ghana continental shelf. So far, Ghana had not taken as much oil and gas, and therefore Côte d'Ivoire argued they have taken less, we have exhausted our part, and therefore we should share in what actually geographically belongs to Ghana as a matter of solidarity. The word was not used, but this was meant. An interesting argument, very much so, but not accepted by the court. And other factors have been proposed. For example, the arbitral tribunal in the case between Barbados and Trinidad and Tobago declared the disqualification of factors as relevant circumstances were always case-specific. The tribunal had declared before that, apart geographic considerations, international courts and tribunals had been in respect of resource-related criteria such as fisheries and hydrocarbons more cautious. The final step was the envisaged delimitation line. Either the provisional equidistance line or the adjusted line will be put to a disproportionate test. If you are familiar with this system, this is an interesting question. Namely, here will be tested whether the maritime spaces attributed to one state reflect the coastal length and the reflection of the coast to the areas, so that there is not a disproportionality between what could be theoretically to one side, but is done otherwise in practice. I will not lead you in the detailed discussion on that, and if you would participate one day, or have done so, in these discussions, in the deliberations of the courts, then you will see how divergent the views are and how the arguments are put. In the end of the day, so far, the approach finally adopted by the ICJ in the Black Sea case was followed in the subsequent jurisprudence by ICJ, ITLOS, and international arbitration under Annex 6 of UNCLOS. The jurisprudence has further refined the methodology of delimitation or delineation, except in one case to which I will come at the end. Can this chain of jurisprudence be considered as an act of interpretation? Only the word equity is what you have. Extended over such a period of time. Interpretation is a means, actually a procedure, of gaining an objectively reasoned understanding of the scope and the content of a legal norm, often ultimately with the aim of applying that norm to a concrete situation. There are other possibilities, but let's accept them. And this double step is expressed in many compromissory clauses of multilateral treaties, such as 286 and 288 of UNCLOS, in Article 9 of the Convention on the Prevention and Punishment of the Crime of Genocide, and Article 38 Convention relating to the status of refugees. Interpretation may also be undertaken in a more abstract context, academic research being the prime example. What I want to say is, if you want to interpret a norm, to implement that in a fisheries case or in a delimitation case, makes a difference. It's never that evident, it's never been claimed. Courts are not that open why they interpret this or the other way. They just do it and leave you in the dark as far as the reasoning behind it. That you have to accept. Therefore, academic interpretation can be more open than the interpretation dealing with a particular case, so be it the Genocide Convention or whatsoever. Every treaty requires interpretation for its application or its adjudication in a dispute concerning such a treaty. The statement, occasionally voiced in pleadings or in literature, not only of students, is the text is clear, therefore it doesn't need interpretation. This is a mistake. For if you say the substance clear, is already the result of an interpretation. Therefore, this is a very strange statement, and occasionally courts criticize parties who argue that way. It's a bit embarrassing. The rules concerning interpretation have their principal origin in the international arbitration practice of the late 19th century. They were developed and refined in a process conducted by fora such as the Institut de Droit International, the International Law Commission, and the Vienna Conference on the Law of Treaties. I very much recommend to you what has been written by Georg Nolte in this respect at this book on the anniversary of the Institute. Every international judgment or award has recourse to the rules on interpretation of treaties, although such a recourse is not always made evident, unfortunately. Many judgment awards referred to below just pronounce a particular result of an interpretation rather than indications the reasons leading to the result of the interpretation exercise. The task of interpretation is, as McNair formulated a long time ago, giving effect to the expressed intention of the parties, that is, the intention as expressed in the words used by them in the light of surrounding circumstances. If one looks into this statement, then one easily sees that even that statement is flawed. But be it is. Also, approaches advocated concerning the methodology of interpretation, whether the original intentions of the drafters of a particular treaty should be most relevant, or the objective meaning of the terms used, or the objective purpose of the agreement. The Vienna Convention on the Law of Treaties managed in Article 31 to find a formula combining all the approaches. Article 31 of the Vienna Convention codifies the general rule of interpretation set out in paragraph 1. The use of the singular noun emphasizes that the provision contains only one single rule composed of 3 elements: the wording, ordinary meaning, and context, object and purpose, as well as the principle of good faith. The textual or literal approach is generally the beginning of the interpretation methodology. Article 31, paragraph 1 refers to the ordinary meaning to be given to the terms of the treaty in their context and in the light of objective and purpose. It is reasonable to assume, until the contrary is established, that the ordinary meaning most likely represents the real expression of what parties intended. I refer to the ILC report 1966. For example, the ICJ stated in the territorial dispute Libyan Arab Jamaria versus Chad that the interpretation must be based above all upon the text of the treaty, paragraph 41. The second element in a process of interpretation is usually the contextual approach, that is to say, an interpretation that analyzes the words and sentences in their context, systematic interpretation. Treaty terms can only be fully understood in taking the whole treaty into account as a context, including preamble and annexes. For example, if you may remember that the law of the sea convention refers that the sea or the deep seabed may only be used for peaceful purposes. Have you thought about what it means? What is only for peaceful purposes? There's no further indication, and the convention refers to that and several provisions. Let's keep, since this is the issue of this seminar, with part 11. What does it mean in respect of the deep seabed? Very good idea. There are some who argue that means that the deep seabed is to be totally demilitarized. But what does then the term peaceful means in respect to the high seas? I can, now you will smile, I will do a comparison with the Antarctic Treaty. The Antarctic Treaty says very clearly, I believe it's Article 1, peaceful purposes, same word, and then it continues as a second sentence, what is all prohibited? No fortifications, no maneuvers, no military weapons, no military personnel, etc., etc. This is a total demilitarization in Antarctica. This sentence is missing in the law of the sea. Therefore, I take the position, but I know that this position is disputable, that peaceful means nothing more and nothing less, the same as it provided for in Article 2, Paragraph 4 of the UN Charter, which means, as a matter of consequence, actions for self-defense are possible. Actions under the sanctions system of the Security Council are possible. Sanctions under a regional organization, Chapter 8, is possible. One can argue otherwise, I know. Those who are from Kiel know somebody who is now living in Japan. You know whom I mean? He sends around papers arguing mostly for total demilitarization. I'll check the name in a moment. He was a worker on a shipyard in Kiel. He was somehow my pupil and covers me with articles, mostly arguing that we should all follow the Japanese constitution in this respect. He was already on a list to receive probably a Peace Nobel Prize, but he was not elected. I'll check the name. Nele, you may know him. Yeah. Having said last, as I said, mostly courts and tribunals do not indicate why and on which basis they reached a particular conclusion. A positive counterexample to which has been pointed by Dr. Khoury is, for example, the order on provisional measures of the International Tribunal for the Law of the Sea in the detention of 3 Ukrainian naval vessels from 2019. Here, the tribunal dealt intensively with the interpretation of the term concerning military activities in Article 298, 1b, using the technique of systematic interpretation. The ICJ used a different approach in the order issued on the same issue. How did the ICJ reach its conclusions concerning the methodology of delimitation in the Black Sea case judgment? It reads, and I quote, a certain part, these separate stages, broadly explained in case concerning continental shelf, Libya, Arabia, Mahia, Balta, have in the recent decades been specified with precision. First, the court will establish a provisional delimitation line using methods that are geometrically objective and also appropriate for the geography of the area in which the delimitation is to take place. So far, a delimitation between adjacent coasts is concerned on equidistance line will be drawn unless there are compelling reasons that make this and feasible in the particular case. See territorial and maritime dispute between Nicaragua and Honduras in the Caribbean Sea. So far as opposite courts are concerned, the provisional delimitation line will consist of a median line between two coasts. This wording does, at least that's my feeling, not sound as interpreting a law, such as Article 74 and 83. Both provisions are not even mentioned. What is evidently irrelevant for the court is that there is a logical connection between the Black Sea jurisprudence and the earlier jurisprudence, namely the judgment in the continental shelf case Libyan, Arab, Yamaria, and Malta. The substantial basis of the jurisprudence since the continental shelf case is Libyan, Arab, Yamaria, Malta, is the equitable principle. In applying the equitable principle thus elicited, and I quote, within the limits defined above and in the light of relevant circumstances, the court intends to proceed by stages. Thus, it will be first make a provisional delimitation by using criterion and a method both which are clearly destined to play an important role in the producing the final result. It will then examine this provisional solution in the light of the requirements derived from other criteria, which may call for a correction of this initial result. End of the quote. But what does it mean in respect of the methodology used by the court? The court gave an answer thereto by stating, and again I quote, however, does this mean in respect of the methodology used by a court, the connection sets a goal to be achieved, but is silent as to the convention, sets a goal to be achieved, but is silent as to the method to be followed to achieve it. It restricts itself to setting a standard, and it is left to the states themselves or the courts to endow this standard with specific content. This is a typical way of interpretation. Well, this part will hardly ever quote it. Secondly, the court in 1982 observed the disappearance in the last draft text, what became 83 paragraph 1, a reference to delimitation by agreement in accordance with equitable principles. It found, however, that it was, and I quote, bound to decide the case on the basis of equitable principle, as well as that the result of application of equitable principle must be equitable again. Page 59, paragraph 70. This establishes, in my view, and this is open for discussion, the development of the delimitation procedure as development of a legal system rather than an act of interpretation. Let me come to my last case. This is a famous case of the ICJ question of the delimitation of the continental shelf between Nicaragua and Colombia, continental shelf beyond 200 nautical miles, from Nicaraguan coast, Nicaragua versus Colombia. Their reasoning, full stop. Let us now turn to this very, very controversially discussed judgment of the ICJ. I'm fully aware, Ximena, that the members of ITLOS are furious about this case, which I quite understand. In this case, the ICJ had to address the issue whether an extended continental shelf of one state could, seen from a legal point of view, overlap with a continental shelf within 200 nautical miles of a neighboring state. The majority of the court declined this possibility. It referred to several judgments which did not deal with this issue altogether. This included ITLOS. And there was a possibility to do so, and it could be done on a different way, and the reference was made to customary international law. Apart from that, the ICJ advanced 3 reasons why the extended continental shelf of one state could not overlap with the continental shelf, the so-called inner continental shelf of another state. The court referred to the obligation under Article 82. If you ever have read this part, you find the arguing a little bit poor. The argument is, to put it into a nutshell, this area is either an outer continental shelf, then 82 is applicable, or it's part of the deep seabed, the area, then it is not. Therefore, Article 2 excludes such a possibility. I'm not totally convinced about that, but be it as it may. And then the further arguments are derived from Article 78, paragraph 8. The court further stated, I quote, that in practice, the vast majority of states parties to the Convention have made submissions to the CLCS, have chosen not to assert the outer limits of the extended continental shelf within 200 nautical miles of the baseline of the other state. This argument seems to be very convincing. However, at least one dissenting opinion argued they didn't really do the proper research on what other states have done in practice. Otherwise, it would be an interesting argument. That Tomka's dissenting opinion in this respect is a little bit very harsh on this point. Judges Tomka, Charlesworth, and Robinson submitted dissenting opinions arguing that the majority of the court had given up the so far prevailing jurisprudence that there was only one continental shelf, although the inner continental shelf was distance defined, whereas the outer continental shelf was geophysically defined. Judge Robinson emphasized that there was no hierarchy between a distance qualified and a geophysical defined continental shelves. Both have the same valence, and accordingly there may be an overlap. He stated that the law of the sea is configured that a coastal state benefits from the full extent of its maritime zones, subject, of course, to maritime delimitation. He finally rejected the arguments of the majority based on Article 2. Judge Charlesworth criticized the review of state practice, which I indicated, and she further mentioned an alternative approach, namely to solve the problem under relevant circumstances. From the point of view of equity, one may well argue that an outer continental shelf claim of one state should not infringe upon the scope of the continental shelf from another state within 200 nautical miles from the baseline. This would mean to engage in a teleological interpretation, considering the quest for equity as a paramount objective. Therefore, none of them has used the term equity as a potential of the solution. However, one could achieve the same result by considering the mandate of international courts and tribunals as a de facto legislation. This is a solution. But the question you would then raise, so what? One could, in these cases, say courts are bound by the legislation or the de facto legislation, and therefore this renders this binding. Judge Charles first hints at that possibility. Let me conclude, but I confess it is a preliminary conclusion. Considering the criticism of the majority reasoning, namely to have set aside the jurisprudence on delimitation, it is worth considering whether there is an alternative approach which better reflects object and purpose. To say judgments bind subsequent courts and tribunals is dogmatically under international law not feasible. Frankly speaking, we do. And in the arbitration between Bangladesh and India, it was clearly said so. Be it as it may, it would be, if we would argue that this is an issue which is, so to speak, settled by an act of lawmaking, then this would indicate that following courts are clearly bound. And as I said, this was already expressed in the arbitral tribunal in the Bay of Bengal between Bangladesh and India, where the arbitral tribunal stated, and I quote, "The ensuing and still developing international case law constitutes an acquis judiciaire, source of international law under Article 38, 1D of the Statute of the International Court of Justice, and should be read into Article 74 and 83, end of the quote. Judge Tomka basically took the same approach, although he formulated it differently as the binding nature of judgments, which is dogmatically problematic, at least for us from the continent. Common lawyers see that difference. Two concerns remain. Would this approach lead to another result than the one reached by the majority in the court? In my view, not necessarily. The jurisprudence quoted by the court did not signal that the limits of the intercontinental shelf were safe against infringements by an outer continental shelf, but also not the contrary. This would have been considered in a hearing as Judge Charles should have been considered in a hearing such as Judge Charles had requested. Depending upon the actual situation, this may be an open question. To conclude, finally, to argue that on the basis of the demand that the jurisprudence of international courts and tribunals should be predictable does not lead to a different result based on considerations that international courts and tribunals have a mandate to progressively develop the regime concerning delimitation of maritime spaces. This is what's been argued. Dogmatically, the latter approach is preferable. The arguments advanced in delimitation cases can in most cases hardly be qualified as acts of interpretation. Thank you for your attention. Soll ich hier, wie wollen wir das? Ich würde mich ganz gern dafür setzen. Normalerweise stehe ich, aber ich bin gesundheitlich ein bisschen angeschlagen.
Thank you very much for this keynote speech. We have some minutes for questions, discussion points on this very fundamental topic, which is essentially the old question of institutional authority versus legitimacy by argumentation or methodology. As we all know, this topic has brought one international dispute settlement system already not only in danger, but actually more or less de facto abolished. That's WTO dispute settlement, where the United States, exactly on these grounds, with the argument that the appellate body edited and diminished rights and obligations with regard to the treaty, has de facto left the system, at least the dispute settlement system. And that was, by the way, not under President Trump, but already under President Obama. So we have a fundamental issue here for discussion that also lays the ground on what we might see or not. That's the question with regard to deep seabed mining disputes, with so many questions, as we will see in this afternoon, open, where we maybe need judicial activism in order to solve some of the forthcoming challenges. But I leave that for discussion. Questions, please. Anybody? Yes, if you, sorry, can you? We have plenty of microphones, sorry.
Thank you very much for your really interesting kicking off of this workshop. My name's James Harrison. I'm from the University of Edinburgh. And I think my question is whether your argument, does it matter whether the court's exercising contentious jurisdiction or advisory jurisdiction for the sorts of role it plays? Is it more likely to enter into more of a legislative role when it's answering very general abstract questions in advisory proceedings, or is it really about the particular rules at play?
Why courts quote other courts, and the ICJ quotes mostly itself, since recently, occasionally ITLOS, but I don't recall that it quotes much arbitration. It's certainly not quoting national courts. The reason why the ICJ quotes itself is, to put it very drastically, to serve themselves the necessity to go through the same issues once again. And therefore it is quoted verbally, for then one is on a, so to speak, safe ground. It is not reflecting whether the previous judgments, Gulf of Maine, for example, is a binding result. So far, it is just said, we have done so before. How could we change with good, if there are no good arguments to change? It's, by the way, the same reason in national courts. I would refer to German administrative courts. They quote exactly in this respect, and they quote the Oberverwaltungsgericht mostly to protect them against that the Oberverwaltungsgericht will not accept the junior court. I have never heard, and I was involved in national jurisdiction, a dogmatic argument in this respect, either this or the other side. This is different in the US. There's reference to an earlier court decision is a must. For the system, the common law system is based on court decisions. But our system, I mean the German National Court system as well as the ICJ, is norm-oriented. We are meant to interpret and implement norms. And therefore, this dependency on previous judgments tells you something how they qualify their own court system and their own legal system. I hope this explains it. It has more dogmatic background than first anticipated. And frankly, in ITLOS, in the ICJ I have no experience to that extent, but in ITLOS I was long enough. There was always a discussion between the judges. I had frequent discussion with Chandra Sekararao, who was typically common law, and he argued in his way, and I did. We were unfortunately sitting very next to each other, but we were very good friends. The other way around. At the end of the day, we very often found a compromise. But the different court systems which have to exist in international courts had their impact. I hope I answered at least in part your question.
Thank you very much. Further questions? If that is not the case, which is fine because we are running out of time, thank you very much again, Professor Wolfrum, for this wonderful keynote starting off on, in general, dispute settlement before the International Tribunal of the Law Sea, but also other institutions. And now we go further and deeper into the subject based on this wonderful presentation. Thanks again. And I'd like to call the panel 1 to the stage, please. Okay, great. Thanks. We are coming to our first panel. We have 2 panels and 1 roundtable discussion. The panels are organized in a rather classical sense of procedural issues and then enforcement. So we are continuing on what Professor Wolfrum already said, but before discussing judgments, we need to come to court, so to speak, and that is what we are going to discuss now. Procedural framework for seabed disputes, the panel is called. We do understand procedural framework in a rather broader sense, including questions of merits, of course. Merits and procedural issues are always closely interlinked. I will introduce the panel to you in a moment, maybe just some aspects of substance. There is, of course, a bunch of questions that come up with regard to deep seabed disputes we did not have yet, but that will come up probably. Questions like, and I just like to give some ideas into the audience, of course, if there is deep seabed mining, there's investment. Does investment protection law, as we know it, play a role? What about international environmental law issues? What are the details on jurisdiction of the deep seabed chamber under 187 and 188? what is the scope and what is of the limitations that we have in the convention, explicitly, as we all know in 189. What does that mean? How can we interpret that? What is the role of arbitral tribunals that are possible on the one side and the chamber, the seabed chamber, on the other side? What is the interrelationship? What is the role and importance in this regard of procedural arbitration rules? What is the role and importance of exit rules? What is the role, and we have that on the panel, of sponsoring states, which is quite a unique, let's say, situation in international dispute settlement. What about possible parallel proceedings, if namely we have a situation where a contractor is involved in a dispute, let's say, with the sponsoring state, back home, so to speak, and on the other side we might have, on the same issue, proceeding maybe here in Hamburg. What is the situation there? What is the role of coastal states? What are there similarities in dispute settlement procedures with regard to other areas, state-free areas out of domestic jurisdiction? What is the role and influence of unfinalized exploitation rules? As we know, they're not yet finalized, on maybe upcoming disputes. What is the role of the implementation agreement in all this, namely with regard to dispute settlement? What is the role of the current exploration contracts that we have already? What if no exploitation contracts can be concluded, but an exploration contract expires? Is that a situation for dispute settlement? What is the role of regulations, of domestic regulations on the issue? We, for example, have a seabed mineral harvesting and other minerals mining regulations of last year of Cook Islands. Do they play a role in possible international disputes? And what if, in a situation, there is a non-action of the international authority? Can a non-action lead to a dispute before the chamber here in Hamburg? And that's only examples of questions. There are definitely way more questions that come up. We will discuss some of them, I guess, in our panel. Others we may discuss in the discussion afterwards. I'm very happy that we have a most distinguished panel addressing some of the issues I highlighted, and others, of course. And I'd like to give you an introduction to our panel. Thank you, first of all, for all of you for being here and agreeing to talk and discuss with us. The first presentation will be given by Ximena Hinrichs, who is the registrar of the International Tribunal for the Law of the Sea. Thanks for joining. She's originally from Chile, but for a long time already, let's say here in Europe, if I may say, practicing and teaching on various occasions, but for a long time being involved, of course, as a specialist in the international law of the sea, and since September 2019, the registrar of the tribunal. Second presentation will be given to us by James Harrison, who is a professor of environmental law in Edinburgh, and he is his particular interest is in the legal framework for the protection of the marine environment, including the regulation of fishing, shipping, disposal of waste, and of course seabed mining, where in all these areas he has numerous publications. Thanks for being here. Elena Guillet, hopefully correct, is an associate in the international dispute resolution and arbitration practice of Vincent and Elkins, based in London. She has extensive experience in international litigation, international dispute settlement, involving states and private parties, including disputes on natural resources in a broader area. She got her education, if I see it correctly, in the UK, if I see it correctly, legal education. And finally, we are happy to have Robert Volterra with us. He is probably one of the most recognized practitioner in public international law. There aren't that many, if I may say, who do specifically and focus public international law, but Robert certainly is among the top, maybe the top one in this regard. He has, and I'm not going to read out all of this, advised governments, private parties, and has appeared before more or less all international dispute settlement institutions and under more or less all international dispute settlement rules and of procedure that are known, beginning, with, of course, with the Permanent Court of Arbitration, ICSID, UNCITRAL rules, London Court of International Arbitration, and so on and so forth. So widespread practice, but not only in general and different aspects of public international law, but also with regard to the law of the sea, natural resources, and all these kind of things. Thanks for being here. We will proceed in our panel in the order the way I introduced the panelists to you. Ximena Hinrichs will give us a general introduction, more or less, on the jurisdiction of the Deep Seabed Chamber. James Harrison will talk about contractual disputes before arbitral tribunals. Elena will focus on the role of sponsoring states. And Robert will wrap up with, if I may say, a general critical view on all this. We are very much looking forward for all of your presentations, and afterwards discussion with all of you in the audience, of course. Please.
I'm guessing this is a touch screen, and if I yeah. My notes there. Right. Good afternoon, everybody. It's an absolute pleasure to be here today and be part of such an esteemed panel and to participate in a conference on a topic that I think is particularly interesting and timely. I'm going to pick up on some of the comments made by Ximena and focus on contractual disputes and really get into one particular provision of Section 5 of Part 11, that's Article 188, Paragraph 2, and it's a provision that's ripe for interpretation. There's lots in there, and there's a lot of ambiguity. It was obviously drafted quite a few decades ago now, and it's never really been interpreted in practice. So, and the system that we've seen under Part 11 has also evolved significantly. We've had the Part 11 agreement, which modifies significantly some of the operational aspects of the Part 11 regime. And that has implications for how we understand the operation of dispute settlement in some respects. Now, the thing I'm going to really focus in on is international commercial arbitration as an exception to the exclusive jurisdiction of the Seabed's Dispute Chamber for contractual disputes. Now, international commercial arbitration, binding commercial arbitration, as it's said in the text here, is a familiar dispute settlement mechanism. But I think my argument today is this is binding commercial arbitration, but not binding commercial arbitration as we necessarily know it. I think there are a number of factors which change how we need to understand this particular system. That's partly dictated by the convention itself and the particular rules in Section 5 of Part 11. And it's partly dictated by the nature of the contracts that are being interpreted and applied in this context. And I'll try and talk you through some of that and highlight at least some of the questions that arise, even if I don't necessarily have particularly clear answers to all of them. So Article 188, paragraph 2a provides essentially a compromissory clause and a binding agreement for parties to contracts to go to binding commercial arbitration for disputes arising out of the interpretation or application of those contracts. This is the residual method for solving contractual disputes. It's an exception to the compulsory jurisdiction of the Seabed's dispute chamber. And the convention text here refers to UNCTAD arbitration rules as the mechanism that states will go to, unless they agree otherwise, or unless the authority in its own rules and regulations provides for a separate dispute settlement mechanism. Now, when this was drafted, it was a time when the UNCTAD rules had shortly been approved in 1976, and there was only one set of UNCTAD rules. There are, of course, now more than one. We've got the 2010 rules as well. And so one question that arises here is which of those sets of rules would apply? In practice, there's not a huge amount of difference between them, and it would really depend upon when the contract was concluded. The 2010 rules suggest that the date of the arbitration agreement is the deciding issue as to whether or not you go under the 1976 rules or the 2010 rules. Perhaps more interesting here is the flexibility for the parties to choose a completely different set of arbitration rules should they so wish. And there might be a variety of factors that are taken into account for those purposes. But also whether or not they want to go to commercial arbitration at all, because paragraph A here makes very clear that the parties can choose another mechanism. Well, what is that? Well, that is at least one option for that is the Seabed's disputes chamber, which, as we've already heard, has jurisdiction over contractual disputes. There are clear differences for parties to dispute as to binding commercial arbitration in the Seabed Disputes Chamber. The Seabed Disputes Chamber is, as we've just heard, made up of 11 pre-selected judges taken from the tribunal. The rules and procedures are set out in the statute annexed to the convention and in the rules of the tribunal. And it's particularly important here, it's an open, transparent set of proceedings where the parties have to plead in public. Compare that to commercial arbitration, where you have a lot more flexibility as to who you choose to decide your dispute. There's a lot more flexibility as to procedure, and arguably also a lot greater chance to remove transparency. Now, this has been an issue in some areas of commercial arbitration. It's particularly come up in investor-state arbitration, and we have new rules now for investor-state arbitration, recognizing the public interest in many investor-state disputes under treaties. UNCTAD have adopted transparency rules which allow for, well, require public proceedings. They allow for third-party participation, and they require all documents to be published. But they're very, very limited to that particular category of disputes. There is a question here, I think, given the nature of Part 11 proceedings, and this feeds particularly into the final round table, the fact that this is the common heritage of humankind, whether or not such transparency should also prevail in the context of Part 11 disputes. But as it's currently set up, commercial arbitration would allow a significant amount of lack of transparency for these disputes, should the parties so wish. And it would be up to the party instigating proceedings to decide whether or not they went for binding commercial arbitration or to the Seabed Disputes Chamber. There are obviously other factors involved in that choice as well, cost being one of them. Are there any other options apart from binding commercial arbitration and Seabed Disputes Chamber? One possibility might be an ad hoc chamber of the Seabed Disputes Chamber. The Convention mentions that, as we've seen, for disputes between states parties, but that's the only context in which an ad hoc chamber is mentioned. doesn't explicitly provide for an ad hoc chamber for contractual disputes, which may suggest that that is not an option. But it begs the question of, well, should parties to a contractual dispute actually be permitted to choose an ad hoc chamber of a smaller number of judges to resolve their disputes? And I think that's a question that I don't have a clear answer to, but the text would seem to lean against it, but there's, I think, a question of whether they should be allowed. Now I can't change the thing. So let me say a few more words about the scope of the disputes that can be submitted under paragraph 2 of Article 188. So this is a reference to disputes concerning the interpretation and application of a contract referred to in Article 187, subparagraph C, little Roman numeral 1. And you see below on the slide the text of that particular provision, which refers to disputes between parties to a contract, being states parties, the authority or the enterprise, state enterprises, and natural or juridical persons referred to in Article 153, paragraph 2b, concerning the interpretation or application of a relevant contract or a plan of work. Now, the obvious scenario here is a contract between the authority and an entity carrying out seabed mining. That's current going to be an exploration contract. In the future, we might be talking about exploitation contracts. It doesn't cover pre-contractual disputes, which would fall within the exclusive jurisdiction of the Seabed Disputes Chamber. And it's unlikely it would cover situations covered by the so-called 2-year rule, where the council can provisionally approve exploitation subject to existing regulations, because it's not clear that that will be in the form of a contract, although that is an area where significant disputes might arise. And again, I would suggest that those sorts of disputes would probably fall within the exclusive jurisdiction of the Seabed Disputes Chamber. So it's a relatively narrow range of scenarios. One question that does arise here is whether we're just talking about disputes between the authority and the contractor. If you look further down the text to Article 190 of the Convention, it suggests a scenario where actually contractual disputes can arise between a state party and an entity sponsored by another contracting party. And this would suggest a slightly wider range of disputes that could fall within contractual disputes, but it's not entirely clear what this is referring to, and the drafting history is also very, very ambiguous. One understanding of this, that this would cover joint enterprises, where you have more than one entity who is party to a contract with the authority, and you might have disputes between the different participants in a joint enterprise. That might be one scenario. Another scenario might be disputes between different contractors under different contracts and trying to work out the limits of a contract. Again, a number of unresolved questions arise, and those may need to be answered, and that would arise in the jurisdictional phase. I want to say a few words about the contract as well, because this comes to my first point about why binding commercial arbitration in this context is different. Because the contracts, and we'll focus here on contracts between the authority and an entity carrying out mining activities, be it exploration or exploitation, are of a particular nature. They're not normal commercial contracts that have been freely negotiated by the parties. And we get a strong hint from both from the Convention, from the Part 11 agreement, but also from the regulations developed by the authority as to the nature of these contracts. The first thing to note about them is actually most of the contracts follow standard clauses that are contained in an annex to the regulations. Annex 4 essentially sets out a set of standard clauses that apply to all contractors. And it's worth noting those are part of the regulations. They have been negotiated by states and are imposed on contractors. And there's very little room for contractors themselves to influence the content of those clauses. The only real negotiations taking place between the contractor and the authority are on the precise details of the program of work to be carried out during the duration of the contract and the training program that's to be provided, which are contained in appendices to the contract. So many of the contracts will be exactly the same, and I think that raises questions about how they should be interpreted and the need for consistency across contracts. The second point to make about contracts is drawn from the standard clauses themselves, which make a clear link between the interpretation of the contract and the interpretation of both the regulations and the convention. There's a huge amount of overlap between the standard clauses and the convention text. Many phrases taken from the convention are contained and transposed into the contracts. And if you look at paragraph 1.2 of Annex 4, it makes very clear terms and phrases defined in the regulations shall have the same meaning in the contract standard clauses. And then you look at also Regulation 1.1, that the regulations also have to mean the same thing as the convention. So essentially, the contract, where they use the same terms as the convention, have to be interpreted in exactly the same way. And again, this changes the nature of the exercise. We're interpreting here state-negotiated language, not language that's been negotiated between the contractor and the authority. To push that point a little bit further, paragraph 13.1 of Annex 4 actually incorporates all the rules of the regulations, all the rules of Part 11, the agreement, and other rules of international law into the contracts. The contractor shall carry out exploration in accordance with the terms of the conditions of this contract, the regulations, Part 11, the agreement, and other rules of international law. This is a very, very broad renvoi, and again, it shows you the very strong link between the contract and the convention. And finally, the convention and Part 11 particularly provides the applicable law for the contract itself. And so the contract has to be interpreted even more generally in light of those principles in the convention. Well, why is this important? I think this links to the other factor which differentiates this form of binding commercial arbitration from many forms. And this is the point mentioned previously by Ximena, that a commercial arbitral tribunal has no jurisdiction to decide any questions of interpretation of the convention. And there's a rather unusual referral procedure set up in paragraph 188, which requires the arbitral tribunal to refer questions of interpretation of the convention to the Seabed Disputes Chamber. Now, bearing in mind what I've just said, what that means in practice is that many bits of contractual interpretation, where the same terms are used in the contract, will actually also require referral back to the Seabed Disputes Chamber and give the significant overlap between the terms of the contract and the convention and the regulations. Arguably, there's very few aspects of contractual disputes that may be within the sole domain of a binding commercial arbitration body here. It's the tribunal itself, or at the request of one of the parties, that such a referral has to be made. And the convention text suggests there's no discretion here for the tribunal. It's a duty of the tribunal to make such a reference. And remember that this is applicable law also for the contract. So this is part of the arbitration agreement and would be binding directly on the tribunal. And once such a reference has been made, the convention text makes clear that the arbitral tribunal shall then proceed to render its award in conformity with the ruling of the Seabed Disputes Chamber, which would suggest that it has no discretion as to what happens next. Now, of course, that assumes that the Seabed Disputes Chamber has given an absolutely crystal clear answer to the question that was referred to it, and it leaves no scope for further interpretation. One question that then arises, well, what if there are still ambiguities? Do you have to have another reference? Do you have to have an interpretation? And there are powers to ask for an interpretation of a judgment of the Seabed Disputes Chamber. This complex institutional setup and the way in which the two systems, the Seabed Disputes Chamber and the binding commercial arbitration, have been articulated by the convention raises real questions, I think, for contractors about why you would go to binding commercial arbitration in the first place. If there's a real likelihood that you're going to have to refer questions to the Seabed Disputes Chamber, that's going to add to the costs of your proceedings, it's going to add to the length of your proceedings, And it begs the question of why not just go to the Seabed Disputes Chamber in the first place and get the whole deal done in a one-er. Now, of course, that would have to be agreed by the two parties to a contractual dispute. But I think there's a significant incentive here for both of those parties to do so. One final issue I'll flag. Clock's behind me. I was told to keep it relatively short, and I'm going to come to an end. But one final question I would add is, if questions arise as to whether or not the tribunal's award is in conformity with the Seabed Disputes Chamber's judgment in a case, that raises questions of enforcement and execution, and possibly feeds into the second panel this afternoon, and how that might be challenged under national law proceedings. And again, that raises uncertainties for parties to commercial arbitration here that may not exist if you go to the Seabed Disputes Chamber, where there's a lot less option for challenging enforcement. Those judgments of the Seabed Disputes Chamber are binding in parties as if they were from the highest national court. So if the parties are wanting certainty from the outcome of a dispute, then again, there are questions about whether binding commercial arbitration is the right outcome. Now, it might have seemed like a really good idea in the 1970s when this was drafted. UNCITRAL rules were new, commercial arbitration was really picking up, and these were, it was anticipated, that these were commercial enterprises that might have disputes that they didn't want to submit to an unknown international tribunal that they couldn't predict what the outcome was. But the question, I guess, really for today is whether that calculation still applies. And I'll leave that one for your own consideration. Thank you.
Good afternoon, and I'd like to reiterate thanks for being on the panel and being able to talk about all these issues with a number of people who have a lot of experience in the sphere. So as mentioned, I'm going to talk about sponsoring states. And this is a unique feature of the convention. So, as Ximena has introduced before, under the convention, the exploration and exploitation of seabed minerals must be carried out under a contract with the ISA, and this contract is subject to the rules, regulations, and procedures. To receive a contract, a private entity must be sponsored by a convention state party, and that private entity must also be a national of that state or be effectively controlled by it. The system of state sponsorship is an indispensable part of the convention regime. As ITLOS stated in its 2011 advisory opinion, the sponsorship is a key element in the system for the exploration and exploitation of the resources of the area. It ensures that the convention, which binds states, is complied at a domestic level. Sponsoring states help protect the area as the common heritage of mankind, and the sponsorship system helps ensure that contractors undertake their activities in accordance with the convention's framework. Sponsoring states have a number of obligations, such as the responsibility to ensure compliance by the contractor, obligation of due diligence and to make best efforts, such as adopting national laws, regulations, and administrative measures, issuing a certificate of sponsorship, inquiring into incidents, reviewing environmental impact state assessments, etc. The role of the sponsoring state is established mainly through relations with the contractor, the private entity that will obtain the plan of work from the ISA. And these legal relations are built on the basis of national law. At an international level, the sponsoring state may become involved in disputes between its sponsored contractor and other actors, as Ximena introduced before through Article 190 of the Convention. I'll also say that the sponsoring state may also itself be subject of legal proceedings for its own state liability. But let's focus now on the role of the sponsoring state as part of the procedural framework in its role as the sponsoring state. So Article 190 deals with the participation and appearance of the sponsoring state in proceedings related to disputes. It allows them to participate in legal proceedings on behalf of natural or juridical persons they sponsor, when such persons are subject to proceedings. However, there is some unclarity relating to Article 190, which should come as no surprise given all the questions raised by the panelists before me. Article 190 fails to explain the legal status of the sponsoring state in the proceedings. Having looked at the Article 190, which states very plainly that a sponsoring state may appear and participate in proceedings, it's reasonable to infer that a sponsoring state could participate as an observer who does not have any legal rights or obligations in the proceedings. It is also possible to infer that the sponsoring state could participate as an intervening third party. As such, substantive and procedural requirements must be met. In accordance with Article 31(1) of the ITLOS statute, it states that should a state party consider that it has an interest of a legal nature, which may be affected by the decision in any dispute, it may submit a request to the tribunal to be permitted to intervene. But there's also legal consequences of appearing as an intervening third party. If a request to intervene is granted, the decision of the tribunal will be binding upon the intervening third state party. Finally, it's also possible to argue that the sponsoring state could participate as amicus curiae because of its special connection with the contractor and its participation being beneficial to the court or tribunal, given the obligations of the sponsoring states, which I just went over a few seconds ago, the obligation of due diligence and ensure compliance. A sponsoring state would have a lot of information which would be beneficial to any dispute relating to the contractor. So, yes, 3 possible interpretations, no conclusive answer. So we'll just wait to see what happens when a dispute arises and the sponsoring state wants to participate. But that's not the end of the question regarding sponsoring states. As I've mentioned, the relationship between the sponsoring state and the contractor is based on national law. The convention and the associated instruments do not specify particular consequences for the termination or the variation of a certificate of sponsorship. It just states that termination of sponsorship shall take effect 6 months after the date of receipt, and in such event, the contractor shall obtain another sponsor within those 6 months. No further provision is made as to what recourse that poor contractor might have, or qualifications on a state's power to end or modify its sponsorship. However, in the 2011 advisory opinion, there was some wording as to what states might or might not do, and it suggested reasonableness and non-arbitrariness when taking these sorts of action, which does not offer very targeted advice. So, as we've stated, under national law, the legal document that embodies the relationship between the state and the contractor is the certificate of sponsorship. That will usually be complemented with a sponsorship agreement, or which is some kind of investment agreement between the state and the contractor, and it'll set out additional legal and financial conditions to that relationship. In addition to this sponsorship agreement, and which will be relevant to the relationship between the two parties, under the convention, the state parties have to adopt national regulation to embody the principles of the convention and ensure compliance with the principles. And these national laws will also dictate the rights and obligations of contractors operating under that sponsoring state's sponsorship. So the sponsorship agreements seek to preserve the economic bargain struck between the two parties. And we have a few of these sponsorship agreements already available. There is the one between Nauru and TMC's subsidiary. There are a number of national laws in Tuvalu which address these specific kind of activities. We have the Cook Island regulations. And as a general theme across these regulations and these sponsorship agreements, there is language that includes recognizable rules of international investment law, such as the requirement for the sponsoring state to accord the contractor fair and equitable treatment, or provide a stable and predictable legal framework, or make decisions consistently and transparently. We also have a number of investment tribunal decisions which state that arbitral tribunals may refer to norms of international investment law to interpret national laws. This was the case in Lahoud and Congo, where the tribunal interpreted a fair and equitable treatment clause within national legislation in light of the principles drawn by the international jurisprudence on this subject. That was also the case in Karatube and Kazakhstan. So we see the norms of international investment law already included in the different sponsorship agreements. The question then arises, and this is a question that is already being asked by the investors in this area who are investing in exploration licenses at the minute, is were foreign entities having to incorporate companies in the jurisdiction of the sponsoring state. Yes, we have a sponsorship agreement. We're provided with certain rights. But what happens when that states decide to just end the sponsorship agreement? And given the political and environmental debate regarding the industry, this is a real fear that investors have. What happens if you just change your mind? And the licenses, the sponsorship agreement will all usually cater for dispute resolution under local laws, the local courts. Maybe as a, I don't know, an American or European company, you might not want to find yourself before the Cook Island courts in a fight against the Cook Island government. You might want a neutral forum. The question is then, if you have this sponsorship agreement and it is equal to an investment agreement, can you have recourse to international investment tribunals? And then the three questions arise. Do you have a treaty or an investment agreement establishing the rights between the two states and entities within those states? Do you have a qualifying investor under that agreement or under that treaty? And do you have a qualifying investment under the treaty? The first two questions can be answered quite easily under existing jurisprudence, the treaty and the sponsorship agreement, and also the qualifying investor. It doesn't really matter that the company who will lose the sponsorship agreement is a locally incorporated company. There is a lot of jurisprudence on reflective losses, and the parent company can claim for losses suffered by its subsidiary. The real question is regarding the qualifying investment. And this is where you see the tension between the international investment law system and the convention, UNCLOS. On one side, investment treaty protection all relates to protecting commercial interests. And on the other side, UNCLOS is a holistic approach considering multiple interests, the common heritage of mankind, and with a strong emphasis on the focus of the protection of the marine environment. Again, also, investment treaty would mean that there is an investment within a state's territory, but we're talking about the existence of extractive activities in the area, which is beyond national jurisdiction. Can we really say that sponsoring states exercise any type of sovereign rights in the area? Also, given that licenses are given to different sponsoring states, encouraging investment treaty, the application of investment treaty principles, wouldn't that create different rights for different contractors within different licenses in the same area? So conceptually, there is quite a big tension between the two regimes. In terms of principles and existing jurisprudence, there are some theories that could provide a practical workaround, like the economic benefits theory, where it's an investment under a relevant treaty, and it's associated with transaction made available and used for the benefit of the host state, or under the economic unity of investment theory, where the host state's non-execution of contracts is for the provision of services outside of its territory. So there are workarounds. The question is whether it is permitted, whether it would undermine the convention's framework to allow for investment, international investment principles to apply. So I'll just leave with this question, but I also want to flag one final thing, and it's the rising tensions for state parties to the convention. A number of states are finding themselves in different positions under the different frameworks with competing interests and tensions. A number of states, for example, are developing their own EEZ for the commencement of exploration and some exploitation activities. They're also sponsoring a contractor for a license in the area, and they're also members of the convention. There are inherent tensions in wanting to accelerate and create commercial benefits for your jurisdiction by promoting the development of your own EZ, whilst at the same time complying with the requirements under the convention of protecting the environment and all the other obligations that are associated with it. So, yeah. Just food for thought. That concludes. Thank you.
Before I start, Christian, we are egregiously behind schedule. That's fine? All right. Take my time. So the first 55 minutes of my talk, I think in my grand old age that a successful conference presentation that I make does two things. One, it challenges every deeply held belief of most of the attendees, and it offends as many people as possible. So I'm going to try and do both. And I'm going to share practical views and experiences over more than 25 years of advising states, resource extraction companies, and financial organizations either interested in or actually involved in deep seabed mining. I'm not going to mention any of them or particular circumstances, but this is the background of what I'm about to say. Nothing about what I'm going to say is theoretical, but I'm going to tell you 5 things, or discuss 5 things in the time I have available. The first is that one of the great concerns about those entities, states, mining companies, financial enterprises, about deep seabed mining and Part 11 and UNCLOS is encapsulated in a Latin phrase, quis custodes ipsos custodias, which I'm sure everybody in this room knows. Who will guard us from the guardians? The ISA has no effective supervisory authority or third-party judicial review. But what is its role? Its role is partly as a regulator and partly as a commercial counterparty to a commercial contract. Oh my God. Can you imagine a universe where the rule of law applies, where a regulator is also a commercial party and regulates its own commercial contract? That is an enormous challenge facing this whole regime. It is enormous. All of us, I'm sure, in this room love the United Nations. We love international organizations. But we know how they operate in terms of efficiency, impartiality, ability to withstand external pressures of various salubrious and non-salubrious kinds. And yet, as you've heard from my colleagues, even the Seabed Dispute Chamber can't investigate their discretionary powers and other powers. That is a serious concern to anybody who's thinking of putting a penny into deep seabed mining. That's what really concerns people who are thinking of putting 500 million, 1 billion euros into one of these enterprises. Secondly, the ITLOS Seabed Dispute Chamber is set up in UNCLOS. It's clear. It's part of ITLOS. It has clear roles. We were taken to them, and its functionality is clear. I'll tell you what concerns states, resource extraction companies, and the people who may lend them money about that. But I'm going to take you away from law and the seabed and the law of the sea. Imagine, and I hope it never happens, that you have to have brain surgery to remove a tumor from your brain. I hope it never happens to anybody in this room or watching on YouTube. But imagine you must do that. And imagine you have a choice, all other things being equal, between 2 hospitals. They're both nice. They both have nice doctors, clean, etc., etc. One has general doctors. One has general doctors and brain surgeons. The hospital with nice doctors, good, competent doctors, decides to create a brain surgery department, staffed by its nice general doctors. So one hospital has a brain surgery unit with nice general doctors but not brain surgeons, and the other has no brain surgery unit but has brain surgeons. Which are you going to choose for your operation? I think the answer is pretty clear. So think to all the international courts and tribunals that have created specialist chambers, given them wonderful names, environmental dispute chambers and so on, and staffed it with exactly the same people who are otherwise generally sitting on the tribunal. How often are those chambers used? How are they perceived? How many states, do you think, have said to themselves, my heavens, the ICJ has set up an environmental chamber. Let's rush off and use it now, because now the people who are going to be on it are environmental experts. Think of how many cases followed that potential narrative. What states, mining companies, people with billions of dollars to put anywhere in the world for any kind of investment enterprise, including the seabed, want for dispute resolution is efficacy, speed, and so on, and people who know what they're doing. We get asked in my firm by financiers and mining companies, yeah, but who are these people? Have they ever negotiated a contract? Do they know what the engineering is involved? How will they be able to tell if there's been a breach or not, if the funding has arrived on time, or if there's been a licensing approval that's been withheld unreasonably? How are they going to know? Do they have any experience? What, have they studied this stuff? Have they done this stuff? Have they practiced this stuff? Thirdly, commercial arbitration and the referral procedure we were taken to comprehensively. It's a bit like the Achmea problem. The European Commission is a jealous lover, and it wants to be in control of every interpretation and application of EU law. Now, those of you who are familiar with international investment law aspects of public international law know that the European Commission has for a number of years been attacking investment treaties writ large, and I'm not going to get into the details of it. But it is because they don't like the fact that these investment treaty tribunals almost always are called upon to interpret and apply EU law, and they want every interpretation and application of EU law to be, like in the national courts, through to a supervision of a European Union court. But how many people in this room realize the only reason the European Commission went after investment treaties was because it originally went after commercial arbitrations? It did. James, we all know James in the European Commission. He's the one attacking the investment treaties and behind Achmea. He first started going after commercial arbitrations. There's far more of them, and they equally have to interpret and apply EU law. But someone pointed out to him that there are about 15 to 20,000 new commercial arbitrations dealing with European Union law every year, and it would be an absolute impossibility to stop those and make all those disputes go to national courts or somehow have the supervisory capability of a European Union court. So it's much easier as a matter of principle and to have a nice job for a few years to go after investment treaties and investment treaty law. But the same problem applies, as you heard, from our James, and sorry, I wasn't referring to James here before, everyone knows James at the European Commission. He pointed out about the compulsory referral process. Well, I'd be willing to predict that if it ever got to the stage where there was a commercial arbitration under these provisions of UNCLOS, that the tribunal would make sure to determine that there was no requirement to give a reference to the Seabed Dispute Chamber of ITLOS, for all the reasons that he pointed out, and because of the impractical and impossible nature of it. But nonetheless, this is something that is a real practical concern, not so much to states, but to mining companies and funders. They don't like that. They don't like that kind of confusion. You heard from my colleagues sort of no disrespect to them. It's built into ITLOS, shoulder shrugging. Who knows? Well, maybe this, I don't know. People who are going to invest $1 billion aren't going to do that. if you had this degree of uncertainty about whether you were buying a flat or a house where you live, you wouldn't put your money in it. Fourth, effective dispute resolution. How many of you have not heard of the Energy Charter Treaty? Good, no hands up. All right. We all know the Energy Charter Treaty was conceived by a wonderful Dutchman and picked up by not just the European Union, but Switzerland, Canada, the United States, Japan, Australia, many other countries. The idea, one of the ideas behind it was to provide a stable legal framework, at least of a general nature, to enable investment from the West into the newly not communist East of Europe. And a very important component of that was third-party binding dispute resolution and very clear dispute resolution provisions. And those of us who were involved in the 1990s and early 2000s in Energy Charter Treaty projects, I was involved in Baku-Ceyhan, all the gas pipelines. The fact that there was this binding, clear dispute resolution for disputes, some to the WTO, some to arbitration tribunals, was one of the fundamental bases on which Western energy companies were willing to invest billions and billions of dollars in energy infrastructure and energy projects in the East. That does not currently exist in relation to deep seabed mining. That is going to hold up deep seabed mining, so if you don't like it, then you'll be happy with that. But if you think deep seabed mining might in some way be good for humanity, that should be a great concern to you, because it's not there. It is not there. Doesn't matter how much lipstick you put on the pig, it's a pig. All right? I'm being very blunt. So what are states and mining companies and funders doing about it? Well, there are a few projects going forward. But in most businesses, and particularly in resource extraction business, you can tell the risk level of a certain geography or business by what kind of companies are investing there. Right? High-risk greenfield projects get high-risk venture capital and high-risk corporate entities involved. Right? You can get mining companies and energy companies investing even now in Eastern Democratic Republic of Congo. But it's not going to be Shell or Total or Mitsubishi. It's going to be companies that are not as established and operate perhaps with different internal regulations and procedures. Look who's doing the licensing applications and sponsorship applications right now for deep seabed mining. Major mining companies? Big international banks? Or not? And what does that tell you, including what the view is in the finance and resource extraction industries about the dispute resolution provisions? There are many other aspects involved, technology, et cetera, but this is telling. Fifth, what are they doing about it? Well, sponsors and mining companies and financiers are putting a lot of pressure on developing countries to adopt lax deep seabed mining regulations. There are a number of countries who have succumbed, and these are being proposed as models to other countries with the temptation that if they adopt them, they'll get some spin-off benefits as sponsoring states. That is the reality of what's happening. National deep seabed mining regulations that don't have really strong environmental impact assessment requirements, cleanup obligations, landing clarities, etc., etc., etc. And above all, what we're seeing is an attempt to contractualize everything, essentially to eliminate in reality the Law of the Sea Convention, bypass the Law of the Sea Tribunal and the Seabed Dispute Chamber, and through contractual networks with the sponsoring state, ensure that everything is moved to commercial arbitration. But even that is a bit uncertain, but that is what's happening. Right? So you're getting a market thumbs down to the dispute resolution provisions that are currently in place through UNCLOS. And you're getting states and commercial entities and financiers interested in pursuing this, engaging in sophisticated, complex restructurings in order to minimize their risk, increase the efficacy of dispute resolution mechanisms, and otherwise. Now, when that happens, when private enterprise and government get together to try and remove themselves from international standards of conduct and supervision, you have to ask yourself, how good is that? What are the implications of that? And how can that be redressed? So, I have the answers. And the answers, oh, I've run out of time. Thank you.
Thank you very much. Thank you very much, Robert, but thank you very much for all of the panelists for wonderful presentations that I think cover really a huge range, obviously, of questions, of legal rules, but more questions than answers, as it has been highlighted. Good and more negative aspects, challenges, and therefore I think we have a lot to discuss. My suggestion would be not to start with a round on the panel, but to immediately open up, if panelists agree, with regard to timing. And of course, the panelists are invited to raise their hands as well to challenge among each other. But I would immediately open up, and I have a first hand here, and then we continue. Please, Frau Matz-Lück.
So from all your talks, from all the excellent talks, thank you. It seems to me that the UNCLOS is not fit for purpose. So there are many inbuilt mechanisms that weren't thought through well enough or that have been overcome by time. So making the, going back to the keynote speech by Professor Wolfrum, what to do now? So for whom would it be up to reinterpret, develop, change the law? Because we also all know that the UNCLOS will not be changed. It's one of these narratives, holy cows, you will not change the black letter law. So whose competence or whose, well, legitimate or not so legitimate function would it be to adapt the system to modern proceedings?
Maybe we, if you agree, maybe we collect a couple of questions, if that is okay, and then we make a round, so to speak. Further question, please.
Question to Robert primary. Which investor would go to commercial arbitration if, in principle, every time I have a question concerning the interpretation of the treaty, and it will always arise, I would have to go to the chamber as well, to the special chamber. Why not go there directly? And perhaps that is a built-in, deliberately built-in, largely exclusion of commercial arbitration. If it is all about protection of environment, the best is we don't invest anything in there. We leave it like it is.
Okay, Professor Wolfrum, and then we make a round on the panel, and then we continue. Professor Wolfrum.
Very brief question. Perhaps my mistake that I have not understood. But what is the status of the authority in international law the status, the legal status of the authority in international law, respectively in national law. This is of essence for the question of standing, I believe. Thank you.
Thank you very much. Maybe we do a round on the entire panel. I would like to give everybody the possibility to if not willing to, then that's fine. You can refer, of course. We start here and then we go on.
I knew I was going to be first. Well, hey. So I think there's a number of general questions, and one of the criticisms is the uncertainty. Right? There are all these rules, we don't actually know how we interpret them. Elena dealt with some, I dealt with some, Ximena dealt with some. So before we can start fixing, I think we need to know what the system does, and maybe we need more advisory opinions would be one way of thinking about that. You know, let's actually figure out what these rules are in advance, and then we can work out whether we really like them or not. We can work out whether or not you can oversee the discretion of the authority under 189, or whether it's a complete blanket exception. I happen to agree with Professor Wolfrum that you know, you can challenge abuses of power. It's not a complete exception, but you know, what is the role of the sponsoring state? So you know, those questions could be addressed through advisory opinions, and that then begs the question of how do we move forward. And I've forgotten all the other questions, so I'll turn to...
Thanks. I think the next question was for Robert, so I won't touch on it. But no, I agree with James in terms that we can't just, without specific issues arising, we can't know exactly how to make the convention and all the associated instruments fit for purpose. Also because we don't know exactly how the industry is going to work. At the minute, we're just doing exploration, but the mechanisms, the technology, the arrangements, that's all very much still being, well, up in the air. I'm not quite sure it's being negotiated or discussed very thoroughly, more than just the collection technologies. So yeah, we'll just have to ad hoc issues and assess. In terms of the, why not go directly to the Seabed Disputes Chamber? Maybe from the perspective of commercial parties, well, there's the issue that Robert mentioned about generalists in a so-called specific chamber. Also less flexibility. It's an institutional mechanism. It's public. Don't want your dirty laundry just out there. So yeah, those are a few considerations, but if commercial arbitration isn't gonna get you the answer you want, maybe there is no choice. Yeah, I'll pass on.
Maybe, Robert, before you, maybe you can add also, we can always refer to courts, tribunals, the chamber, and say they will fix it. But are contracting parties, are the states being members of the convention, are ready to accept that, if that would be the solution?
Well, advisory opinions are always fun to do. They're great fun. I can tell you, James, the advisory opinion that you envisage, I can tell you what it'll say. It'll say, on the one hand, on the other hand, and there's two sides, and in all reasonable interpretations, possibly in appropriate circumstances, maybe. And that's about as useful as the paper it's written on. With all respect to every international court and tribunal that's issued an advisory opinion to date. But who knows? And so commercial parties aren't going to be satisfied with betting the company on that. perfectly frankly. So I think the best solution would be to create a time machine and send Professor Wolfrum back and kick down the nasty little group of Shabtai Rosen and people who wouldn't let other people like him sensibly talk to them about dispute resolution. Until we discover that time machine, to be frank, I think probably the best thing to do would be for the states to participate meaningfully in the ISA discussions about the creation of rules and regs, and to try and have a sensible set of rules and regs about dispute resolution arising out of that, that would effectively modify those relevant provisions of UNCLOS, but in one of those gentle public international law ways that if enough countries accept it and enough countries act according to it, no one will challenge the constitutional nature of it, and it will be viewed as interpretation subsequent to. So that's what I would suggest. Secondly, why would commercial parties not just go straight to the SDC? Seabed Dispute Chamber. For the reasons I think that have been mentioned before, that's not something I think that would attract commercial parties. I think what they will try and do is contract around it as much as possible so that they can constrain the ability of the tribunal to seek that kind of referral. Remember, the referral only happens if either proprio motu or on the proposal of a party, the commercial arbitration tribunal decides that there is a question that must be answered. Right? So there is no recourse to the correctness of that decision. If the commercial arbitration tribunal decided, in ways that are consistent with the New York Convention, and they use a bit of creative language to characterize either the facts or the arguments in a particular way, they could avoid it. And I think that's what parties would try to do to contract around it. Third, what is the legal authority or status of the International Seabed Authority in international law? Well, reaching back to the days when I was teaching international organization law at the University of Paris, I would say that it is a functional international organization with limited competence, and therefore recognized on that, should be recognized on that basis in the domestic legal systems of the countries that are participating in the treaty regime.
Thank you very much, Ximena.
Thank you. Well, I think we are focusing here on one category of disputes, and what I attempted to do was to describe the whole system, and it goes beyond the settlement of commercial disputes. This is only one of the categories. So this is important, the settlement of disputes, this comprehensive settlement of disputes mechanism in Section 5, of course, were incorporated in order to take account of what's going on in the area and to take account of the principles that govern the area and the common heritage of mankind, one important principle. So yes, I think it's a fit for purpose, so I tend to start from that premise. We should not just focus on the commercial arbitrations and these problems of the referral. There is no jurisprudence, so the system has not been tested, it has not been used, so we don't know in which circumstances a referral would be made to the Seabed Dispute Chamber. In preparing my presentation, I took the time to look for articles, academic articles, and that it's not much written on this subject. So I think for those professors in academia that should invite students to work on and to write more on how this could be interpreted. There are different, of course, there could be different views. The current regulations, and I happen to have them here, is in the draft regulations for mining. the current text as it's being negotiating. It's in Regulation 106, and it refers to the disputes concerning the interpretation or application of the exploitation regulation shall be settled in accordance with Section 5 of Part 11. So that's where the states today, in 2025, so many years after the convention was adopted, that's what they are discussing. Of course, there is also, I didn't have time to present the advisory opinion. I think the advisory opinion, which Judge Wolfrum participated, it has been seen by the authority and by states as making an important contribution and to what the obligation of states, sponsoring states are, what obligations they have, and I believe it is in terms of the area regime made an important contribution. The authority, it's of course an international organization, and it administers the common heritage of mankind. I mean, it has a very important role and has judicial standing in before the Seabed Dispute Chamber. And what the discretion, this question of the discretionary power of the authorities, also there are in academic articles different views, but I would agree that there is no total prohibition in terms of how to interpret this discretionary power, that whether this discretionary power is absolute. I quoted what Judge Wolfrum had written on this matter. That seems to be the preferable view, and I think in an article you wrote, James, with Mr. Pecco Naro, they are also supporting that view. Thank you.
Thank you very much. We have one more round of questions before we have a coffee break. I have two questions there, please.
Thank you, Julia Truhl, International Human Rights Law. Thank you for your informative talk. May I play devil's advocate, please, and suggest a solution to all those challenges you named? How about using all your wonderful expertise and put that into better to improve the regulations for recycling resources and stop destroying our planet altogether with seabed mining, which is utterly disgusting thing even to consider doing that, as long as we haven't looked at what we are going to destroy and if we are not harming ourselves more with this exploitation. Thank you.
Thank you very much. I think that is an issue we are coming back to on the roundtable later on also. There are two, yeah, please.
Yeah, thank you very much for your comments. My name is Elena. I'm a PhD student at the University of Hamburg. Since Nauru triggered the 2-year rule, there has been a lot of discussion on a potential moratorium or a precautionary pause on deep sea mining. And my question is, if this takes any kind of formulation, whether this could give rise to disputes. Thank you.
Well, I guess what you're referring to is the concrete question on whether, if we will not see rules, and there is an application, maybe this summer, whether there is possibility for legal challenge to get a decision without any rules on the comprehensive mining code. Anybody willing to pick up this issue? Any questions? Any further questions? I'm sorry. Oh, I'm sorry. I'm very sorry. We have very bright light here. You cannot see it from your side, so very sorry if I didn't see you.
No worries. So this is a question that's principally for Elena, but of course I'd be grateful for anybody's views on it. So the second paragraph of Article 190 has this curious provision where the respondent state, if a claim is brought against it by a national or company of a sponsoring state, the respondent state can ask the sponsoring state to come and appear on behalf of the national or company in the proceedings. And then there's a provision that says basically that the responding state doesn't have to do that, it can do something else. So when I read that, what that says to me is diplomatic protection. That if the sponsoring state appears on behalf of the national, then essentially it's going to be an international claim by the sponsoring state on behalf of the national that would be subject to the rules on diplomatic protection, which could have some significant implications. For example, if a company is sponsored by the Cook Islands but has no headquarters there or finances there, then there could be an argument as to whether that company actually, a claim can be asserted on behalf of that company. On the other hand, that provision is limited in its scope to contract claims, which are not international claims in the ordinary way that that is understood. And so it seems strange for this provision to be there, and I would be grateful for any insight as to what it's supposed to do.
Thank you very much. Then I close the questions, and everybody is invited. I don't want to force anybody to speak who is willing. And
well, I said
well,
I like offending
ahead.
people at conferences, so I'm happy to keep doing so. In relation to the recycling resources question, certainly my remarks, and I imagine perhaps everybody's today, was looking at the question posed, abstracted from broader questions of environmental protection, human rights, and so on, and human. So my comments were purely encapsulated by the construct of the questions. I personally, in a non-legal way, commend recycling and so on. I think the question of deep seabed mining is complex, not just because of the environmental possible implications of deep seabed mining, but broader sort of questions. And the human toll of certain kind of mining for certain kinds of rare minerals in certain parts of the world is appalling. And I'm not prepared to make an evaluation between a degree of environmental degradation, but 1,000 children a year not dying in open mine pits in awful parts of the world, so on. But I think your concerns are very real. And like most environmental and climate change issues, I say the problem is you. And you, and you, and you, and you, and me, right? You used a microphone to speak. I have no doubt there are rare earth minerals in this microphone. I'm using it too. You got here somehow, and unless it was on a bicycle, there was some consumption of energy. Me too. I mean, I'm not picking on you, but we are all to blame for these things. And one of the problems is, collectively, we just don't care enough to have a significant impact on our reduction on our what we perceive as our quality of life. But that's a broader debate, but your issues are very relevant. Precautionary pause question. I think those may well give rise to disputes. But perhaps not the kinds of disputes that you might have in mind. I think they might give rise to various kinds of disputes between sponsoring states and commercial entities that you'll never see. That's sort of what I would, or suspension of payments or return of payments by sponsoring, by commercial entities to states. I think that's the sort of thing that would happen. I don't think, for example, I'm projecting, but I don't think any investors or mining company would, sue the ISA or something like that. It'd be ridiculous, I think. But I think they would, they'd ask for their money back from the sponsoring state. They'd ask for penalty. They probably have contracts that say, if there's this suspension, you are responsible and will pay me the cost of the capital that I put into it. That sort of thing. So I wouldn't be surprised. And then third question, even though it was Elena, I think those provisions were inserted in the historical context of the Cold War and the fact that there was such a significant amount of direct state commercial activity that didn't translate easily into Western concepts of contract and responsibility, and we saw the same sort of phenomenon on the various kinds of investment agreements between Russia and Swedish companies and Finnish companies and dispute resolution of the Stockholm Chamber of Commerce and so on, where there are distinctions between Soviet, the Soviet as a state, Soviet company, and I suspect that it had to do with that rather than any grand vision of conflating commercial dispute with international dispute. But that's just my guess.
Thank you very much. Just as a footnote, you probably know the letter a number of contractors has sent to the authority, making kind of at least giving the idea that they might sue. But who knows, whatever. Please.
On the question on the sponsoring states, I was just going to add that I don't have an answer to your question, but I do find that provision to be inconsistent with the other obligations and the treatment of state liability of sponsoring states, particularly under Article 139 or Annex 3, Article 22. Whereas, well, that provision basically opens the door for a state to appear on behalf of its sponsored contractor. But the advisory opinion and the provisions which I've just mentioned really clearly establish that the responsibility of the sponsoring state and the contractor exist in parallel. They cannot be replaced one for the other. Whereas if you ask the sponsoring state to appear on behalf of the contractor, you kind of how do you distinguish the liability of the two different entities as clearly as they are in the convention? I don't know, just...
Well, I was just going to say in response that it wouldn't be a liability on behalf of either, because the scenario is that the company or the national is bringing a claim against the respondent state. So there wouldn't be a question of liability, it's just a question of who's presenting the claim and potentially whose claim is it.
Thank you very much. I give you the opportunity, but no, it's James.
I mean, as Professor of Environmental Law, I can't help but respond to the point about recycling, which is one well made on the substance of this. There's a risk, though, isn't there, that if it comes back to the point Robert made, that if we don't have a good regulatory structure in areas beyond national jurisdiction, are these mining companies going to go elsewhere? Is that going to be, pursuing land-based resources where there are also egregious, human rights violations, environmental problems? Is it going to be mining within national jurisdiction and finding states? Right.
We can. The We come back to that as indicated in the roundtable, where we will discuss those concerns in light of the Common Heritage principle and other issues. This panel was on dispute settlement, and I think we have a wonderful picture on the legal grounds, the framework, but also the huge challenges ahead. We'll see how that will develop, with an active role by courts and tribunals and lawyers and whoever. Thanks very much. Thank you for the panel. Thank you for the audience for questions. This was a wonderful start. And we have a 20 minutes break. We are not too bad in terms of timing, until 12:30. and then we continue with the second panel. Yeah? Thank you very much.
Oh. I'm a lawyer, I don't like to be in the spotlight. I operate from the dark. Well, ladies and gentlemen, dear colleagues, dear friends, let's start with panel 2, enforcement of decisions. Why is that relevant? Well, once all briefs have been written, once all pleadings have been held, once the court or the tribunal has deliberated, at some point in time of the life of a lawyer, you'll receive a huge bundle of paper. And you look into it and you'll see you've won your case. And then you call the client and the client say, oh, jolly good, how do I get my money? Or my license? How do I get that, what the tribunal / court / tribunal told the other party to do? That is the decisive question. If you cannot already at the outset confirm your client that all the money which you're going to spend on a case will lead to a result which will help your client, then there will be no case. Now, for an arbitration lawyer, enforcement usually is not a very difficult topic. Commercial arbitration awards are enforced under the terms of the New York Convention. We have some nearly 170 contracting states. There's a relatively straightforward path, which means that arbitration awards rendered in one contracting state must be enforced in another contracting state absent certain mandatory reasons. So you can go to the courts and say, please enforce it, and the court has to do it unless one of those reasons exists. Then there's the Exit Convention for Investment Disputes. In the Exit Convention, you also have a very self-contained framework for recognition and enforcement. You have Article 54. Contracting states must treat exit awards as if they were final judgments of their own courts. And also, nearly every contracting state by now has enacted a law transforming that obligation into domestic law. So if you now want to enforce an exit award, for example, in Ukraine or in Argentina or somewhere else, in one of the nearly 160 contracting states, you know how to do it. There is a reliable framework. UNCLOS is potentially a bit different. It at least does not seem to have a comparable enforcement instrument, but that's what we're going to discuss. It relies, like a classic international tribunal, heavily on state cooperation and domestic legislation. You have, of course, ruled that decisions, for example, by the Seabed Disputes Chamber are binding. There is in Annex 6 the Article 39, which is strikingly similar, at least it appears, to the exit regime. But still it's untested and it's not as comprehensive. So we are going to look at these different enforcement regimes and questions and try to find out, would a decision be enforceable? How would it be enforceable? And look at different aspects. Our first panelist would be Nabila Abdul Malik. She is a partner at Fersken Martineau in Canada. Nabila is called to the bar in England and Wales, in Malaysia, New York, and Ontario, and specializes in investment arbitration as well international trade and investment. She has represented corporations, investors, and sovereign states before courts and tribunals, and provides legal advice in relation to a broad spectrum of issues and industries, including mining. Nabila will outline the key UNCLOS articles on enforcement, explain how they apply to deep seabed mining, and show us where interim or provisional measures might come into play. Our second panelist will be Jonathan Lim. Jonathan is a partner at WilmerHale in London. He is a triple qualified English solicitor, Singapore advocate, and New York lawyer with a focus on complex international disputes. Jonathan has a broad practice representing clients in all types of commercial and investment treaty arbitrations across a broad range of industries, including aviation, energy, and mining. And Jonathan will focus on how obligations under UNCLOS translate into real-world enforcement against sponsoring states. I think we all agree that this is highly interesting and relevant after the discussion which we had in the first panel. And he'll draw on various instruments in case law. He'll also discuss whether Article 39 of Annex 6 constitutes a waiver of sovereign immunity and how this might need to be interpreted in the light of recent exit decisions. Our third panelist is Bart Legum. Bart is a partner at Only Legum in Paris, and he is recognized for his expertise in investment treaty arbitration and public international law. In addition to decades of private practice at prominent international law firms, Bart's career includes years of government service. He has served in the office of the legal advisor of the US State Department. In that latter role, he acted as lead counsel for the US government in defending the first arbitrations against it under the North American Free Trade Agreement. And at least while under his tenure, the US has won every case heard. Bart will shift the enforcement focus to the Indonesia Seabed Authority and the enterprise. He'll examine whether the immunities present unique hurdles to enforcement compared to sponsorship states and how existing frameworks, exit or the New York Convention, might or might not help successful parties in seeking to enforce decisions. Our last panelist is James Boykin. He is a partner at Hughes, Hubbard & Reed in Washington, D.C. Jim focuses on cross-border commercial disputes and international arbitration, and he has hands-on experience in enforcing arbitral awards against states, including the complexities of seeking specific performance. And why is that relevant? It's very simple. If you want to have an exploitation license, you might not be satisfied by an award for damages. You do not, if you're a mining enterprise, then you want to mine. And you do not want to file claims for damages. And claims for damages also have the problem that nobody knows what will come out of it. So James will address this very critical issue of non-monetary relief, in particular specific performance. When the disputing parties are exploring deep sea resources, he'll discuss how and why specific performance is sometimes the only meaningful remedy, and explain the challenges in enforcing such awards as illustrated by his experience with India and US courts. When you listen to all of our panelists, bear always in mind this inherent tension between international instruments and the necessity to enforce it by instruments of national law. With that, I'll give the floor to our first speaker, to Nabila.
Thank you, Richard. I'd first like to say that it's an honor to be here before this gathering of distinguished guests, esteemed colleagues, to speak about a topic of growing importance, enforcement. After all, the efficacy of international law and disputes framework hinges upon the robustness of enforcement and compliance mechanisms to ensure that legal determinations are not merely symbolic, but are implemented efficiently. With that, let's dive in. Pun intended. So the first enforcement-related clause in UNCLOS that I would like to discuss is about the enforcement of decisions by the Seabed Disputes Chamber, which is grounded in Article 39 of the ITLOS statute, and that's in Annex 6 to UNCLOS. And that article states that the decisions of the chamber shall be enforceable in the territories of the state parties in the same manner as judgments of or orders of the highest court of the state party in whose territory the enforcement is sought. So the language used in this provision has some similarities with Article 54, sub 1 of the Exit Convention, which states, each contracting state shall recognize an award rendered pursuant to this convention as binding and enforce the pecuniary obligations imposed by that award within its territories as if it were a final judgment of a court in the state. So state parties, like contracting states, must recognize decisions by the chamber and enforce them. The wording of the provision implicitly precludes domestic courts from reviewing the decisions or acting as appellate bodies. It requires direct enforcement. Now, if a state party does not have specific laws concerning enforcement of decisions by the chamber, this same legal mechanism that applied to enforcing judgments from a nation's highest court can be used. Unlike Article 54 of the ICSID Convention, Article 39 of ITLOS statute does not limit the scope of enforcement to pecuniary obligations. It also does not state that the execution or enforcement of the pecuniary damages be governed by the laws in force in the state, but it can be presumed that domestic laws would apply to that stage of enforcement. Article 296 of Part 15 of UNCLOS, which states that decisions rendered are final and binding. And also Article 21 sub 2 of Annex 3 to UNCLOS is also relevant to enforcement. And in that article, it says that any final decision rendered by a court or tribunal having jurisdiction under this convention relating to the rights and obligations of the authority and of the contractor shall be enforceable in the territory of each state party. In contrast to Article 39 of the ITLOS statute, which pertains specifically to decisions made by the chamber, Article 21 sub 2 applies to final decisions by any court or tribunal with jurisdiction under UNCLOS. So what does this all mean and what are the challenges that present? So first of all, enforcement relies heavily on domestic legal frameworks and the compliance and cooperation of state parties to implement decisions. This decentralized approach can lead to inconsistencies and challenges in uniform enforcement. However, as demonstrated by the successful enforcement of ICSID arbitral awards, whose enforcement regime bears similarities to the enforcement mechanism under UNCLOS, this approach can still nonetheless be effective. Second, some states may resist compliance or enforcement due to political, economic, or strategic interests, which could lead to selective compliance or enforcement of decisions. In particular, states with significant investments in seabed mining may attempt to circumvent unfavorable rulings by invoking domestic interests or national security considerations. Additionally, some states lack the political leverage or institutional capacity to enforce compliance on powerful multinational corporations operating under their sponsorship. Another challenge is that sponsoring states bear legal responsibility for ensuring compliance with environmental and regulatory obligations. So if a state fails to fulfill these obligations, enforcing a decision on liability may be challenging. This issue is particularly relevant where developing states, which may have limited regulatory or supervisory capacity, act as sponsors for private entities. A failure to comply or enforce decisions in such cases could undermine accountability and weaken international environmental and safety standards in seabed mining operations. Fourth is what the panel earlier were discussing. It's about overlapping jurisdictions. So the involvement of many actors such as the authority, sponsoring states, contractors, other state parties, and other users of the marine environment creates a web of legal relationships governed by overlapping but different legal requirements, potentially leading to conflicts in decisions rendered and also their enforcement. So this web of legal relationships affects the type of disputes, the type of enforcement mechanisms available, and potential for legal remedies in the case of a breach. Also, enforcement efforts can be further complicated by jurisdiction of non-state parties' domestic courts. Non-state parties may enact domestic laws governing their activities and their citizens' activities in the area, as the US has done with the Deep Seabed Hard Mineral Resources Act. This creates the possibility of conflicting or overlapping claims to mine sites and disputes related to deep seabed mining being adjudicated in domestic courts of non-UNCLOS parties, potentially leading to conflicting decisions and further complicating enforcement efforts. Another issue for us to consider is the clauses related to enforcement in the standard clauses of exploration contracts that are entered into between contractors and the authority, and also in the draft exploitation regulations and future exploitation contracts. Clause 25.2 of the ISA contract for exploration, for example, it stipulates that any final decision rendered by a court or tribunal having jurisdiction under the convention relating to the rights and obligations of the authority and of the contractor shall be enforceable in the territory of any state party to the convention affected thereby. The same wording can be found in Regulation 106 of the Draft Exploitation Regulations of Mineral Resources in the area, and also in potential future exploitation contracts. Compared to the enforcement provisions that I explained earlier under UNCLOS, these clauses add a slight nuance, noting that enforcement applies to any state party to the convention affected thereby. This seems to suggest the enforcement of decisions relating to the interpretation or application of an exploration contract or the draft exploitation regulations or a potential future exploitation contract is targeted to states with a direct connection to the dispute. This targeted approach raises some intriguing questions. How do we determine which states are affected thereby? Does this depend on the nature of the dispute, the parties involved, or the potential impact of the decision? One can interpret the term affected thereby to mean only the state parties that are parties in the dispute. Another interpretation is that affected states could include coastal states who have jurisdiction over marine areas adjacent to the area and whose interests may be impacted by deep seabed mining. This is supported by Article 142 of UNCLOS that requires due regard for the rights and legitimate interests of coastal states. One can even expand the interpretation of the term affected thereby to encompass all state parties by virtue of the common heritage status of deep seabed and the general obligation of states to protect and preserve marine environment. Now, my next topic is about provisional measures. The chambers and any court or tribunal that considers it has prima facie jurisdiction over deep seabed mining disputes possesses the power to prescribe, modify, or revoke provisional measures to preserve rights of the parties or to prevent serious harm to the marine environment. This authority is enshrined in Article 290 of UNCLOS, which grants, like I said, the Chambers, Court, or Tribunal the power to prescribe any provisional measures which it considers appropriate under the circumstances to preserve the respective rights of the parties to the dispute or to prevent serious harm to the marine environment pending the final decision. Article 25 of Annex 6 to UNCLOS also reiterates that ITLOS and the Chamber have the power to prescribe provisional measures. The Chamber is also empowered to act in default, pending the constitution of an arbitral tribunal, to determine whether or not to prescribe, modify, or revoke provisional measures in deep seabed mining disputes, provided that the parties could not come to an agreement within 2 weeks from the date of a request for provisional measure for another court or tribunal to decide on that request. The procedural elements for granting provisional measures under ICSID provide a useful comparison to the framework under the UNCLOS regime. Under ICSID, a tribunal must establish 5 elements before granting interim measures. The first is prima facie jurisdiction. Second is prima facie establishment of the case. Third is urgency. Fourth is imminent danger of serious prejudice or necessity. And the fifth is proportionality. These requirements ensure that provisional measures are granted only when there is a clear and compelling need to protect the parties' rights and prevent irreparable harm. The ICSID framework reinforces the idea that provisional measures should be carefully calibrated to the circumstances, balancing the urgency and necessity of the measure against its potential impact. The criteria under UNCLOS for provisional measures are similar to those under ICSID. A party must demonstrate, first, the chamber or court or tribunal has prima facie jurisdiction over the dispute. Second, urgency of the situation requires provisional measures, which has been interpreted by ITLOS to require a, quote, real and imminent risk of irreparable prejudice, end quote. And third, if the provisional measure requested is regarding the marine environment, then there must be prevention of serious harm to the marine environment. These criteria align closely with those applied in ICSID proceedings, reflecting a shared commitment to preserving rights and preventing harm pending a final decision. When it comes to enforcement of decisions regarding provisional measures, Article 39 of ITLOS statute, which pertains specifically to decisions made by the chamber, appears to support the enforcement of orders of provisional measures made by the chamber, as it states that the decisions of the chamber shall be enforceable. And this can be interpreted to encompass both interim and final decisions. However, when it comes to a court or tribunal with jurisdiction under UNCLOS, the enforcement clause in Article 21 sub 2 of Annex 3 to UNCLOS provides that any final decision rendered by the court of tribunal shall be enforceable. This appears to preclude interim decisions or decisions regarding provisional measures when rendered by a court or tribunal which has jurisdiction under UNCLOS from enforcement. What this means is that UNCLOS requires enforcement of decisions rendered by the chamber concerning provisional measures, but is silent on decisions rendered by a court or tribunal concerning provisional measures. That gap is addressed by the obligation to comply. Parties to the dispute are obligated under Article 290 sub 6 of UNCLOS to promptly comply with any provisional measures prescribed. ITLOS, for example, maintains a continuing role in monitoring compliance as parties are required to submit reports detailing the steps taken to implement the prescribed measures. This mechanism underscores the binding nature of such measures and the expectation of adherence by the involved parties. Although not explicitly addressed in UNCLOS, it can be expected that the chamber or court or tribunal with jurisdiction over a deep seabed mining dispute would do the same and monitor compliance with any provisional measure ordered. While the duty to comply with treaty obligations is a widely recognized principle enshrined in international instruments like the Vienna Convention, this duty does not always result in compliance. This is especially pertinent in the realm of deep seabed mining. The legal complexity surrounding enforcement of decisions in deep sea mining disputes that we're discussing today is particularly pressing as the world plans to move from exploration to exploitation. The emphasis in UNCLOS is rights, legal obligations, legal responsibilities, and the expectation of full compliance. Enforcement comes second, resulting in gaps in the regime. However, despite these challenges, the UNCLOS dispute settlement system has a favorable record of compliance, at least according to a 2023 study by Klein and McNally about over 29 UNCLOS decisions. And in that study, they found that there were only 3 instances of clear non-compliance. The remaining cases demonstrated either some degree of compliance or lacked sufficient information to assess compliance. So while acknowledging room for improvement, the study found that this record reflects positively on UNCLOS and its dispute settlement framework. The study's focus remained on discerning whether or not states actively sought to comply or deliberately chose not to implement specific orders. The nuanced approach provides a more comprehensive understanding of the complex dynamics of compliance with the decisions. This favorable record of compliance and cooperation of state parties, even though it's only based on a small pool of UNCLOS decisions, when it comes to decisions rendered under UNCLOS, it gives us hope, at least some hope, that there will be voluntary compliance with decisions rendered in deep seabed mining disputes, at least by state parties, sponsoring states, and the ISA, the authority, and that enforcement will only be pursued in the minority of cases where there is non-compliance. And that concludes my remarks. Thank you.
Thank you for having me. It's a real pleasure to share this blinding spotlight with such a great panel. I thought about dropping slides, but I'll keep them because I'm going to refer to some statutory language, and maybe it keeps things interesting. So in general, enforcement comes last in time, temporally last, but certainly it's of utmost practical importance to parties to a dispute. Paper judgment is no good if it's not complied with. Enforcement deals with what you can do if a party doesn't comply with that paper. It's also worth mentioning that it's usually a remedy of last resort. The best situation for parties is often voluntary compliance with a judgment award that renders unnecessary enforcement steps. And typical commercial investment cases, at least ones that we get involved in, one often sees quite a high degree of compliance, whether for reasons of reputational risk avoidance or the preservation of relationships, or even sometimes the threat of enforcement. And so the existence of a compulsory mechanism for enforcing judgments or awards itself can encourage voluntary compliance. So let me start there and say I will be focusing today on enforcement against sponsoring states, just thinking sort of concretely of kinds of disputes that might arise and how you might seek to enforce decisions obtained against sponsoring states or state contractors with contracts with the ISA. As you know, they play a critical role under the UNCLOS, and I don't need to go through that. They'll have obligations under UNCLOS, under the treaty, but also there'll be parties to contracts, sponsorship agreements, services contracts, subcontracts, all kinds of contractual relationships will form around the exploitation of a particular area. What happens upon non-compliance of a sponsoring state of its obligations, contractual, treaty obligations, and if a case is brought and a decision rendered, what can one do to enforce such a decision? If we look at the next slide, not sure if I can control it. Yeah, magic. So this is the reason for the slide. There's a nice diagram and things. So there's the three main pathways I tried to illustrate, three different legal frameworks. First, state-to-state dispute resolution. It's always a possibility under Part 15 for state-to-state disputes. At the international level, as you all know, there's no machinery for the enforcement of decisions by international tribunals and courts, like there would be in a domestic civil litigation. And there are no obvious municipal judicial mechanisms for enforcement either. Like Richard said, there's no New York Convention-like treaty that would provide for the enforcement of such decisions by national courts. And of course there wouldn't be, because national courts are not by design intended to be instruments for enforcement of such decisions, particularly given the presumptive independence and equality of states, and obviously principles of sovereign immunity, which I'll get into. So typically, the enforcement of such decisions takes place through resort to the good offices of international institutions, self-help, diplomatic means. I'll call these political, not legal mechanisms. Looking to the center, you have commercial arbitration awards. Here I'm talking about Article 188 2A contracts, but not just those contracts. There'll be all kinds of contracts surrounding a dispute, and those may have their own arbitration clauses. We looked at some of the issues relating to Article 188 earlier and some of the issues coming out of that, but there'll also be other contracts that have their own arbitration clause. Let's think of those all within that middle bracket. Commercial arbitration. Who are the parties typically? You look here to the principle of privity, so whoever's party to contract. You might have difficult cases in a penumbra about non-signatories and whether they're parties to the contract, but in general, this is a straightforward question. How do you enforce this? It's pretty straightforward. The New York Convention has, as the date of last checking, 172 parties. Articles 2, 3, and 5 of the Convention obligate contracting states to recognize and enforce international arbitration agreements and international arbitral awards, with limited exceptions. And specifically, contracting states that are parties to the convention will have enacted legislation implementing the convention, which then gives you a statutory instrument that reflects the provisions of the convention that I referred to. Importantly, the convention has been acceded to and ratified by most significant trading states, including most of the sponsoring states. The convention, I say most because not all. Obviously, Nauru and Kiribati are not party to the convention. But there's generally widespread ratification, and that's just a point to note for the middle column. The fun part of the discussion relates to SDC decisions, which is to the right side. So this is pretty unique, as you know. The SDC, the Seabed Disputes Chamber, is a sui generis body in terms of the parties that can appear before the tribunal. It's also pretty unique in terms of the enforcement provisions. And although decisions of international tribunals and courts are not generally enforceable by judicial mechanisms, as Nabila pointed out, there is Article 39 of UNCLOS Annex 6, which is pretty unique in addressing enforcement, providing that decisions of the chamber shall be enforced in the same manner as judgments or orders of the highest court of the state party, in whose territory the enforcement is sought. This provision may have direct effect in some jurisdictions where international law may be self-executing. That is not the case for Singapore and the UK, which I'm more familiar with. They are dualist systems whereby international law doesn't have direct effect, and therefore, with the exception of customary international law, needs to be implemented via legislation. And so that's led to the enactment of two interesting statutory provisions, which I'm going to look at with you very briefly. So, in 2015, Singapore enacted the Deep Sea Mining Act. Sections 18 to 20 establish a framework for enforcement of Article 187 decisions by the Seabed Disputes Chamber. Both Singapore and UK enacted these legislation in about 2014, 2015, shortly after the Case 17 advisory opinion was rendered. Among the sponsoring states, as far as I could tell, only Singapore, the UK, and New Zealand have done this. So, Section 18 allows an interested person to apply for the registration of a decision of the SDC. So registration is a reference to a concept whereby a judgment, a foreign judgment, is turned into a judgment of the Singapore courts. And therefore, you can then access all the usual mechanisms for attachment and so on that is available to the enforcement of domestic decisions. It's worth noting here the reference to a decision of the SDC without qualification. That's different from the UK statute, as I will get onto. Interestingly, interested person is not defined. This indicates there must be some sufficiency of interest, but the exact threshold appears to be something that the court is free to, within reason, determine in individual cases. It's possible that other state parties, the authority, even if not a party to the actual case, may actually be an interested person that can take advantage of this provision. That could be an interesting question. You'll also note that Section 18, subsection 2, clarifies two things. First, that even a decision involving a state may be registered under Section 18. So you might have purely state-to-state decisions rendered by the SDC. They appear to fall within the scope of Section 18. Section 18.2 makes clear that nothing in the section should be taken as affecting a defense of immunity, and I'll get to this later. Section 19 spells out the effects of registration. Effectively, then it becomes basically a judgment of the High Court of Singapore, with the consequence that all the normal powers of the Singapore court attendant to Singapore judgments would then apply. For completeness, you can also see Section 20 there. It deals with arbitral awards under Article 188.2a, whatever those may be, and however they may look like. It says, whatever they look like, we deem them to be a New York Convention award. Looking now to the UK statute, Section 8a, this was amended in 2014. Just pointing out some key differences. It qualifies the decision of the Seabed Disputes Chamber. While the Singapore statute was unqualified, this refers only to Article 187 CDE, to the exclusion of AB, obviously, and F. That's disputes between state parties concerning interpretation of Part 11, and disputes between state party and authority regarding acts or omissions alleged to be a violation of Part 11 and so on. Registration has the same effect that we saw earlier, translating that decision into a judgment of the UK courts. And finally, Section 8c provides that Article 188.2a, commercial awards, again, whatever those may be, whatever those may look like, are to be deemed to be an award under the New York Convention. Interesting footnote, these refer to decisions, not final decisions, which is language you see in other treaties and statutes. To a point Nabila made earlier about provisional measures, I think it's open to interpretation and certainly submission that these apply to the enforcement of provisional measures, decisions as well. I know you love these statutes, but I'm going to move on. So when looking again practically at enforcing an SDC decision, you've got it on award against a sponsoring state before national courts. I think it's hard to escape the practical considerations of state immunity. If a sponsoring state is found by the SDC or an arbitral tribunal to be in breach of its obligations under contract or treaty and does not wish to comply with that decision, it is likely to invoke the doctrine of immunity in proceedings before national courts to register and then enforce those decisions. In most jurisdictions, and you all know this, the concept of absolute immunity has eroded over the years, and obviously in most places a restrictive notion of state immunity now endures. That is the case in the UK as well as in Singapore, and statutorily given effect in the confusingly similarly named State Immunity Acts in both respective jurisdictions, one in 1978 and one in 1979. And so a key question, if you're really trying to enforce against a sponsoring state in the UK or Singapore, is whether one of the statutory exceptions to state immunity under those acts is satisfied. In particular, whether there is a prior written agreement to submit to the jurisdiction of the enforcement courts, or alternatively, an agreement in writing to submit disputes to arbitration. These are the exceptions contained in Section 2 and Section 9 of the UK State Immunity Act, which have virtually similar provisions in the Singapore Act. Here I found UNCLOS article, Annex 6, Article 39, interesting. For reasons Nabila has pointed out, there are some similarities to ICSID Convention Article 54. But just look at the text of the convention, because that in itself is interesting. There is no reference at all to immunity. At the very least, it doesn't refer to immunity in terms. It just states that the decision shall be enforceable. It is an international commitment, creating responsibility on international plane to enforce SDC decisions in a contracting party's territory. But for the purpose of the UK and Singapore, the real question is it a prior written agreement, express agreement to waive state immunity? And that's a really interesting question. Article 54 of the ICSID Convention, first sentence is more or less similar. There are differences that Nabila has pointed out, but some of the key language that courts have relied on is there in both treaty provisions. And in several recent cases, including in England, most recently the ISL versus Spain case, the English Court of Appeal has interpreted Article 54 as satisfying the statutory exception to state immunity in Section 2.2 of the State Immunity Act, on the basis that that is a prior written agreement, an express agreement to submit to the jurisdiction of the English courts. The High Court of Australia reached the same result. Both courts held that on a plain reading, Article 54, in plain terms, is an agreement by a contracting state to recognize and enforce ICSID awards in its own jurisdiction, and that awards to which it was party to would be recognized as if it were a final judgment of the domestic court of that state. Both courts held that this was an express waiver of state immunity. I tried to start from the language because you can imagine this is not an obvious conclusion, but it is a conclusion the courts reached, and is now the law in Australia and the UK. As a result, the English Court of Appeal dismissed the arguments by both Zimbabwe as a joint appeal and Spain that Article 54 should not be read as an express waiver of state immunity. I mentioned those cases because that reasoning is likely to be instructive to the extent an enforcement action is brought in the UK or Singapore against a sponsoring state. Although there are some minor differences, the key language relied upon by the courts exists also in UNCLOS Annex 6, Article 39. Finally, just going back to arbitral awards, I was looking at SDC decisions. With respect to immunity, as stated in the ISL decision, as long as the state is a party to a valid arbitration agreement, that also would satisfy the Section 9 exception to state immunity. So to briefly conclude, there hasn't been an actual case, so most of this, you were promised a practical discussion, but I've actually just been talking out of my pontification. But given the important role played by sponsoring states in the Part 11 system, there will inevitably be some kind of disputes, whether commercial or under other dispute settlement mechanisms, and the effective functioning of those dispute mechanisms depends on effective enforcement. Unclear though it is, and sort of imperfect though it is, I've tried to suggest that there are available some mechanisms for enforcement and suggested some ideas about how we could interpret them and apply them. Thank you.
Right, so you've heard about the framework for enforcement with respect to states and the framework more generally. What I'm going to address, and it will be brief, is the framework for enforcement with respect to the International Seabed Authority and the enterprise. So the question is, what is different in this particular context when that's what you're talking about? And there are a few significant differences. So the first is that we've talked a bit today about the ICSID Convention. The ICSID Convention would not apply to the authority or to the enterprise. The authority is not a state, and therefore it is not an ICSID contracting state. And similarly, the enterprise is not a company or a national of a state. So the ICSID convention would not apply. Now, an interesting question would be whether the ICSID additional facility rules would be available. And those of you who, like Richard, are ICSID rule nerds will remember that in a couple of years ago, ICSID amended its additional facility rules essentially to allow the European Union to participate in ICSID additional facility arbitrations. And the amendment that was done was by adding a definition for RIOs, for Regional Economic Integration Organizations. And so now the ICSID additional facility rules extend to RIOs and their nationals, or constituent units, as well as to states and nationals of states. Now, by any normal conception, the authority would not be a RIO. It's not regional, it's international. However, if you read the definition of what the defined term RIO is in the ICSID additional facility rules, it's an organization constituted by states to which they have transferred competence in respective matters governed by these rules, including the authority to make decisions binding on them in respect of such matters. So, can an argument be made that the authority falls within that definition? Maybe. I'm not well-versed enough in the topic to be able to express an opinion, but it seems to me that it could be arguable, although why anyone would go that route when other perfectly good arbitration rules are available is a bit of a mystery. But the ICSID convention is not available. ICSID additional facility rules, question mark. The other big difference is with respect to immunity from enforcement. Now, international organizations are subject to a different immunity regime than states are. And, we talk about the concept of absolute immunity for states. Well, that absolute immunity is subject to a number of exceptions, whereas for international organizations, as a general rule, there are no exceptions to immunity. And the UNCLOS Convention with respect to the authority is along those lines. So in Article 178, it specifies that the authority, its property and assets are immune from legal process. So you can't sue it. You can't serve process on it. No court can have jurisdiction over it. And then in Article 179, it says that the property and assets of the authority, wherever located and by whomever held, shall be immune from search, requisition, confiscation, expropriation, or any other form of seizure by executive or legislative action. Now there it does say executive or legislative action. It doesn't refer to judicial action. So there is a question mark there that could be raised. But as a general proposition, the expectation is that you will have the right to go to arbitration against the authority or to have disputes heard by the seabed chamber, but you will not have any other recourse in court because there's no means to serve process on it. The enterprise is different, and that's dealt with in Annex 4 in Article 13. So judicial actions may be brought against the enterprise if it engages in a commercial activity in the jurisdiction in question. There's a number of other provisions, but essentially they're all encompassed by commercial activity. So you'd have to show that the enterprise engages in commercial activity before you can serve process on it, which would mean if you had an arbitration award against the enterprise, then in order to enforce that award, you couldn't enforce it just anywhere. You would have to, reading the provision literally, you'd have to be able to show that the enterprise engages in some form of commercial activity there, which is a different standard than that applicable in a number of countries' approach to the New York Convention. The other thing is that the property and assets of the enterprise are not subject to seizure before judgment. So while you can get provisional measures against the enterprise, you can't enforce those measures by seizing property. So if you got contempt sanctions, as a matter of principle, you would not be able to enforce those against the enterprise. However, the fact that it says before judgment implies, of course, that after a judgment is reached, that the property and assets are subject to judicial seizure, assuming that you can bring a claim in a jurisdiction that actually has, where it has commercial activity. Those are the main differences in claims or enforcement of awards or decisions with respect to the authority and the enterprise. And in the interests of speeding things along, I think I will stop there and turn it over to James.
All right, thank you. I cannot think of actually a better segue into the subject of specific performance than some of the challenges you identified to monetizing an award, especially when you're faced with absolute immunity. You know, why did I want to talk about specific performance? Richard alluded to it at the beginning. You know, he gave a very sort of intelligent lawyer's explanation. Mine was going to be bitter experience, or curiosity informed by bitter experience. So let me start with the story of the bitter experience, and it involved, now we weren't involved in the underlying arbitration, we were involved in enforcing an arbitration award under the New York Convention. In the US, where the court shall confirm unless one of the exceptions applies, then it may decide not to. This award, what the situation that occurred, a US company was exploring for oil and gas in India's territorial waters. A dispute arose whether the term of the contract that allowed that exploration had lapsed. And that depended on just certain facts, and there was a dispute over whether those facts were established. So the contract between the government of India and the US company provided for arbitration. 3 distinguished former justices of the Supreme Court of India presided over the arbitration and unanimously held, no, the US company continues to have 3 years, and India, you must allow them to continue to explore. Now, Richard made in his initial kind of summary a really important observation. And because we hadn't conducted the underlying arbitration, I'd always ask myself, why didn't they ask for damages? Well, Richard just gave me the answer. Too uncertain. They hadn't found anything. So specific performance in this case was what they bargained for, what they'd invested for. I mean, I suppose they could have caused, maybe sunk costs, but what they really wanted was the 3 years of rights to try to make the money. And, U.S. is an arbitration-friendly jurisdiction, but the district court refused to confirm. And the judge reasoned that he could not confirm the award because of doubts about his authority to grant specific performance outside the territory of the United States. Now, I took some issue with that because we weren't asking the judge to grant specific performance. The 3 justices of the Indian Supreme Court had already done that. We just were asking the judge to recognize under Chapter 2 of the FAA and confirm the award. But that does render it a U.S. judgment, and so I could sympathize with the judge's point. But then he also was concerned that it would violate U.S. public policy to order a foreign sovereign about the management of economic activity in its territorial waters. Now, we were talking about disputes outside of territorial waters. This was inside territorial waters. But this experience, in case, made me wonder when Richard first drew to my attention the existence of Article 187 and 188 and these dispute resolution provisions, would we have gotten a better result in this context in the deep sea bed under the UNCLOS Convention? And so I started to, read them for the first time. And Professor Harrison, thank you for remarking about all the interpretive issues in 188 because I thought I needed to go back to law school. I can't tell you that this is a complicated document. This is, so anyway, I felt your remarks made me feel a little better. I found a really good article published by the Max-Planck Institute. It was written by Michael Lodge, Secretary General of the International Seabed Authority in 2017. And it has a nice little handy divider of these types of disputes would be covered, these types would not. And it's an excellent, 5-6 page primer that I would highly recommend anybody read. So, talked about the bitter experience. Would we, would we have done better now that I've read and worked through this very complicated treaty? Where does every arbitration lawyer start? Applicable law. What is the applicable law? That's in Article 293, and I'll read 293.1. A court or tribunal having jurisdiction under this section shall apply the convention and other rules of international law not incompatible with it. Other rules of international law. Is specific performance a remedy available under international law? One instinctively wants to say, yes, that's obvious. But that it's not so obvious when you think about the premise that states are co-equal sovereigns, and this is embedded in Article 157.3, nature and fundamental principles of the authority. The authority is based on the principle of the sovereign equality of all its members. So with specific performance and sovereign equality, who can tell who what to do? But there's some obvious examples out there of the remedy existing. I mean, for instance, our firm represented a woman pro bono, a Bolivian woman who had been raped by a family member when she was a child, and the perpetrator wasn't prosecuted. She got asylum in the United States. We brought a claim under the Inter-American Human Rights Convention, and we got an award where they directed Bolivia to change its laws. So and Bolivia did. And I mention that because that's a sort of happier example than the ICJ's case ordering Russia to get out of Ukraine or the ICJ's case on Gaza. But there are international bodies that grant specific performance. So I think we can safely say it's a remedy available at international law, but you do need to have some body where states have conferred the power to order them to do things. So how is that going to happen? And others have identified these provisions, but I'm going to go back to Article 296, finality and binding force of the decision Any decision rendered by a court or tribunal having jurisdiction on itself shall be final and binding and complied with by all the parties to the dispute. Super! That's also what the treaty between Germany and India says. Does that mean that India is going to pay Deutsche Telekom what India owes it? No. So how do you enforce that type of provision that it says it will be all the parties agree to comply? And I want to mention Article 39, which one of my co-panelists mentioned. The decisions of the chamber shall be enforceable in the territories of the state parties. So there is the possibility that you could take the decision into the courts of a state, and that's one way you could do it. But this problem of co-equal sovereigns and who's going to order one to do something, it reminded me of what Andrew Jackson said after John Marshall, former Chief Justice of the United States Supreme Court, found that the Native Americans had sovereignty over their territory. He said, John Marshall has made his decision, now let him enforce it, and then thus began the genocide of the indigenous population of North America. And yes, Mr. Trump, if you're watching on YouTube, I called it a genocide. Now, political enforcement, that's the mechanism that you can find. It's a little bit like the European Court of Human Rights. And it's in Article 185. And it's basically, the only thing you can do when everybody's co-equal is create incentives. It's kind of the Charlie Munger quote, show me the incentives, I'll show you the conduct. Article 185, Part 1 says, a state party which has grossly and persistently violated the provisions of this part may be suspended from the exercise of the rights and privileges of membership by the Assembly upon the recommendation of the Council. All right, not following an order for specific performance may affect rights and privileges of membership. What are the rights and privileges of membership? One easy one to identify was being able to vote in the authority. You can lose that. But you can't find any full definition of all the privileges. But there did seem to me to be the possibility to argue that if you're not complying, you're not going to receive some of the economic benefits under the agreement. And it seems to me that the treaty was left with a little bit of deliberate ambiguity on that point, but that it's part of a built-in incentive structure to incentivize compliance with awards in a relationship where no one can force the other to do anything. So I'll sum it up. Specific performance is an available remedy under international law. I think that this treaty and the incentive structure it created could possibly have led to a better result in the case that, prompted me to think about this. I hope I haven't been too wild and woolly. I'm feeling jet lagged, but it's also, I'm standing between you, the final panel, and cocktails. So thank you for your attention.
Test? Works, fine. Now it's question time. Anders, there's an urgent question. I have a first one inspired by what you, Jim, just said, posed to all four of you. We think in terms of enforcement of awards because we normally deal with actors from various states and we need to import the legal force of an award into the legal system of the other state to enforce it in that state, to get access to assets or force a party to do something. In your case, which you mentioned, you referred to Indian territorial waters. Now, do we really need to enforce a decision of the Seabed Disputes Chamber which relates to the area? Because that is outside the territory of any state. Could we, just as a creative idea, could we circumvent it by asking not for damages, not for an obligation to do, but for something like, please declare that I have the license. Please declare that the termination of a license revocation is unlawful. Please declare I can do this. Would that be a way? Are we perhaps too much constrained by our conceptual thinking of traditional commercial awards, which you need to enforce within the sovereign area of a state, but we refer to something else?
The short answer is yes. I don't think the UN Convention, or the New York Convention, I'm not sure the drafters really anticipated awards against sovereign states. And Justice Costas in the DC Circuit recently authored a dissent where he reasoned that an award under an investment treaty is not a UN Convention award, and therefore all states enjoy sovereign immunity. And it's well reasoned. I disagree with it, but it would ruin our practice. But your question draws that out. There's this regime for enforcement that was primarily intended for commercial actors that has sort of been used in the different space, public international law and against sovereigns. And it was there and it was used, and this is highlighting some of the issues with it. And that's why in the end I kind of I presented the bitter experience, but I kind of sympathized with the judge. It's like, what do you want me to do? It's their territorial water. Why don't you go there and enforce it? India's a signatory. But yeah, so Richard, I think you've put, yes, we're trying to use the New York Convention is a wonderful treaty, but it's sort of grown out of its clothes. The metaphor is escaping me, Bartle.
Well, so what I was going to say is simply that, of course, it's difficult to imagine the scenarios that will develop in this new regime because we don't have much practical experience with it. But let's say hypothetically that you had a petroleum reservoir that crossed from the exclusive economic zone of a contracting state into the high seas. You'd have to have what in oil circles is called a unitization agreement, where you have an agreement that although the petroleum is going to be extracted from one well or two wells or five wells or whatever, it'll be divided up. The proceeds will be divided up depending upon some assessment as to how much of the reservoir is on one side of the border and how much is on the other side. If the wells are all being drilled by a state-owned oil company, by the state that has the shore, for some reason I'm not remembering the right word, but if they're all being drilled by that state, then there could very well be a need to have enforcement of a decision if that state has a different view, let's say, as to what the right unitization is.
Good point. So what do we do? What should a company, a claimant, someone who needs to enforce do in order to make enforcement possible? Jonathan,
I'm looking at Jonathan because it's a question that involves states.
I wasn't picking up the mic to answer this question, but I was going to say, I think to echo a point that Bart made, it kind of depends on who's involved and what you need. I think, Richard, you raised a really good point that for some disputes, there's no point thinking about judicial enforcement mechanisms, right? There is nothing a court can give you that would be useful. Disputes against authority, the all-powerful authority, not much you can do in the UK courts, Singapore courts. If you need something to be done in the area, an area outside national jurisdiction, I think equally one's got to be a lot more creative about remedies. And I think, in the end, as you say, a declaration may have effect. I think you can then use a declaration to get other forms of relief. You might use it I mean, depending on the situation involved, I mean, a contractor might have a sponsoring state, you might have diplomatic means, you might have other means of recourse, but they will not be legal means, I think, as I said earlier. I'm not sure what else I can say about the legal mechanisms there.
Any views on that?
Well, I think obviously it's a good strategy to try to obtain as many remedies as you could. So even though, for example, declaratory relief, there's a big question mark as to how you can enforce it and whether or not it would have any teeth. But I think it would be a benefit in these types of disputes, like as you rightly pointed out, because of all the things that they've explained. And also it could well be that just having this declaration, even though you might not be able to enforce it right away, in the future, things may be different. Policies may change, the government may change, maybe there's more technological, scientific studies are involved that would allow this kind of exploitation. And also, because under UNCLOS, obviously they respect right of priority and preferential right to advance your project. So even if you lie in the weeds and technically you couldn't really advance your project, you would always have that right. So even if you can't enforce it right away, it may be different in the future.
Christian.
Yeah, thank you very much. Two questions, comments. One, I don't know who's competent on answering. With regard, maybe Bart, with regard to enforcement, voluntary or court enforcement against either the authority or the enterprise. I think one has to add one further aspect, and that is the budget of the authority. The annual budget is about 22 or whatever million US dollars. That is with regard to the investment that is at stake and could be in, let's say, in a dispute, become relevant nothing. So we, in a scenario, whatever that is, we could run into the old and classical, maybe you remember public international law class at law school, scenario of the insolvency of an international organization, of the International Tin Council. And then the question of whether member states have an obligation, whether they are liable, whether they have an obligation, and so on and so forth. It's really an underfinanced system in this regard, with regard to disputes and enforcement issues. First. And secondly, Jim, with regard to specific performance from a purely public international law perspective, I would say if we look at ILC articles on state responsibility, we have, of course, the primary obligation is always, if we have a wrongful international act, restitution, that is to say re-establishment of the situation as it was before the wrongful act, as long as specific performance is identical to re-establish, or is what you are referring to going beyond the re-establishment of the situation of legality. Then, of course, we would have more problems legally.
And I thank you for reminding me of the Articles of State Responsibility. I was going to look at them when an associate called me at 1 in the morning last night, and we had to edit a brief, and I forgot to put them in my outline.
Article 35.
It's the obvious source to look to. But I did want to engage in a little shameless self-promotion of our firm's work before the Inter-American Human Rights Court, and I wanted to also sort of take a dig at Russia. So I kind of like to focus on the jurisprudence, but you're absolutely right. And thank you on that first point, too. That's maybe I'd love to talk more with you about that. And I have to say, it's nerve-wracking to talk about this treaty, which I really just kind of looked at for the first time over the past month, in front of professors of public international law who have studied this, who study public international lives and are familiar with this instrument. So it was with enormous trepidation that I stepped out. But thank you for that observation.
I was just going to say...
Okay, sorry.
No, please go ahead.
No, we have an intervention from
In terms of the financial means of the authority, I guess two observations. So one is, yes, it's 2 or 3 million a year right now as the budget. On the other hand, there's been a total of about $80 million in investment in the area, at least according to something I read from December of last year. So it's still very early days, and if deep seabed mining ever does take off, then the financial means of the authority could be really quite substantial.
Okay, one small comment from me to what you said, and then we'll give Christian. I agree with you that reparation is the primary remedy, but shouldn't we differentiate between the right and the remedy? So not every right is procedural. So now, Rob, is it you? The light shines so much. Is it you or the spotlight?
Yes, it is. This was just a brainstorming thought and a combination of listening to an observation you made, Richard, and what Christian just said, and then what all the panelists have been saying. So this is just free-flow brainstorming, but Bart's right about the potential future assets of the authority enterprise, but those are all flow through to the member states, right? So it's not going to have a big holding. And what it does is probably going to be operational and blah, 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 so it's going to be consumed. Shouldn't prospective claimants against the authority or enterprise be looking for declaratory relief along the lines of confirmation of validity of licensing and so on? Because that doesn't involve the improbable payout from the ISA enterprise, which strikes me as just highly improbable. And both practical challenges in terms of assets they have are going to be spread out. They're supposed to be paid out effectively in dividends immediately, and various kinds of problems with immunities in enforcement. But that sort of ties in to what everybody's been saying on the panel as well. I mean, is that not the most likely, just looking at the authority and the enterprise, isn't that the most likely rational approach? Is because any declaratory relief that comes from the dispute resolution provisions of UNCLOS, regardless of the previous discussion of how awful they are or whatever, any one of those should be automatically binding on the ISA and enterprise without any other further requirements, sort of thing. Anyway, just to brainstorm. Love to hear comments from the panel. Well, and if it's a bad idea, say so.
Well, Robert, you probably have more experience with international organizations than I do, but my experience is that they are very law-abiding, and that if an award is rendered against them, then they will find a way to comply with it. And so that would be my expectation. And the question is simply, yes, you're right, there's a flow-through aspect, but if they've got to pay an award, then that would ordinarily be operational, so that would be paid before dividends.
My thinking was if the real damages are like $2 billion, what's the reality? That was my thinking, not sort of small little breaches.
Any further questions? Otherwise, I suggest we have a short break as intended. And any further question might be dealt bilaterally, and then 15 minutes? Yeah, 15 minutes break, and then we reassemble here for the roundtable discussion. Thank you very much.
I will start talking while one of our panelists is getting ready to come over. You will see only 4 people on the podium instead of 5. So I will take a seat. But Pradeep Singh, who was on the program as to be confirmed, had confirmed in between and then had to cancel last night as he is going to Fiji. Not maybe a good alternative to Hamburg, although he sends his regrets for not being here. So we're going to have a roundtable now on the common heritage of humankind and the relevance for disputes. And before that, after the panel and before the formal farewells, we do have a few remarks on maybe how to publish papers from the panel. Now, still stay here, don't run away. It's usually, for academics at least, sounds more like a threat if you suddenly say you have to publish something. When we planned the conference, the question was whether to talk about I know what you say about the lights. To talk about the common heritage may be a bit too academic for a conference that is supposed, and I think it has worked extremely well, that's supposed to bring more a practical perspective into seabed mining disputes. Still, we would like to have the discussion particularly from the perspective of if there is a relevance of the common heritage of humankind in our dispute settlement. Now, if all my panelists will say, no, there is none, I will have to make up some questions. You have already met and been introduced, or they have been introduced to you, James Harrison and Bart Liggum. We have two fresh faces on the panel here. One is Nayade El-Khoury. She's a senior researcher at the Max-Planck Foundation for International Peace and the Rule of Law. And we have Carsten Rühlemann here, who specifically reminded me again that he is not a lawyer, so don't put the really tough legal questions to him. He's a geologist by training, and he works for the Federal Agency for Geoscience and Natural Resources, and he's also a German member to the Legal and Technical Commission of the ISA, so he does actually have a quite good insight of what legal questions are being discussed. So if we talk about the common heritage of humankind, and we started with a keynote by our Judge Wolfrum on interpretation, the convention doesn't give us a lot on what's actually meant with the common heritage of mankind, as it's called there, and we try to be more inclusive by labeling it humankind, but you can say however you like. We have Article 136, and then we have Article 311, paragraph 6, saying, oh, whatever you change, whatever amendments you make, whatever inter-se agreements you do, you cannot change the concept of the common heritage of humankind, but doesn't really tell us what it is, and that, I hope, makes it even more interesting to discuss what potential relevance this principle or concept or whatever it really is. We will not go into legal theory too deeply, what this could mean for dispute settlement. And we haven't really fixed the order of statements. I'd like to start with introductory statements by our panelists, and then I hope that already you will get into a conversation with one another. Otherwise, I will ask questions to you, and then we open this to the audience. And maybe we just proceed from here on. Mr. Rühlemann, starting with you, and make our way through, if that's okay. Otherwise, you can agree otherwise. And I will sit in the middle, I think. You can start? Yeah, we had our thought maybe to start with some introductory statements.
I can start with some very general thoughts and statements. I've already had a bit of my piece already. So I know this is a conference on dispute settlement particularly, but I actually thought it would be useful to pan out and talk about how dispute settlement fits within the bigger governance structure, because for me, the common heritage of humankind, goes to the institutional framework and the role of the authority in representing the international community as a whole. It is, in a sense, the guardian of the common heritage of humankind. And it's also a unique international organization, and we shouldn't forget that. It is one of the few international organizations out there that actually regulates stuff directly. And I think that has massive implications for the way we need to think about it, what it does, and also how we keep it accountable. So one element of that regulatory function is yes, it has powers to regulate individual actors, but it also has a number of duties upon it, which are all related to this principle. There's 136 is the first of a number of principles set out in, I think, section 2 of part 11, that also talk about the duty to promote the safe and orderly development of activities in the area. One close to my heart, Article 145, the duty to protect the marine environment, expressed in very particular terms, actually, in much more specific terms than many of the provisions in Part 12 on the marine environment. It talks about preserving the ecological balance of the area. It's quite interesting language in Article 145. And also on the other side of that, beyond those kind of balancing between promoting development and protecting the environment, are obligations to ensure the uniform application of the regulations between the different contractors and to ensure non-discrimination. So in a sense, for me, the common heritage is how those different duties need to be balanced in the exercise of the regulatory functions by the authority. Now, we've talked a lot about dispute settlement as a way of enforcing today. I also think we need to remember that the authority has powers to enforce without even going to court. It has powers to impose monetary penalties directly on contractors without the need to sue them. There are conditions on that. The penalties have to be proportionate. And if the contractors are not happy, then they have an opportunity to take the authority to court to challenge that. But this is not like kind of private commercial litigation. This, for me, is a little bit more like judicial review. They're challenging a regulator and trying to ensure that it's sticking to its duties. And I think that mindset of judicial review permeates quite a lot of the dispute settlement regime and is inherent to this idea of common heritage. And one final point is that we also need to understand the authority, which we've spoken about that a lot, but it is a series of organs made up of states, but very particular decision-making structures, a lot of power conferred on the council, which has its various chambers representing different interests of the international community. And so when we think about, when the authority takes decisions to enforce, it's the council members who take that decision, and there are different interests represented in that. When the authority is deciding whether or not to comply with an award against it, again, it will be the council and the balance of interest between the parties who ultimately decide what response. So I don't think we can completely separate that judicial element of the Part 11 regime from the broader political governance. I think I'll probably stop there for now.
Thank you, James. I have an immediate question back before we move on, actually, because what you've said in the beginning about the role and the function of the ISA as a kind of, Ximena said earlier, the ISA is the administrator of the common heritage of mankind, but we have an ISA who is not only, if there is a protective element in the common heritage of humankind, which we can discuss, maybe it's just an exploitation principle, that is something to decide. But at the same time, via the enterprise, which is not yet operational, but could be, it has its own interest in exploitation. So how well does that go along? So sort of maybe imposing restrictions on others for the sake of the common heritage of humankind, while at the same time having a commercial interest, so to say, in exploitation.
Yeah, just throw the difficult questions at me straight away before anybody else has spoken. Thank you. So I agree there's a tension there. Obviously, the enterprise has its own decision-making structures and governing board, which is subtly separate from the authority, and I think there was an attempt to have some independence. How successful that is, I think we could debate. And obviously, the enterprise is not yet operational, and when it does become operational, it has to be through joint ventures with contractors, which does change the nature fundamentally. The Part 11 agreement fundamentally changes the nature of how the enterprise will operate. It also dictates that the enterprise has to have a contract with the authority, which changes the original text. So I think it's incredibly complicated. But there are attempts to try and keep those different functions separate, and there's a debate about how successful that is. I think that's a fair question.
Thank you very much for starting with a difficult question. We move on, Nayade.
Thank you. I would like to first start sincerely to thank Professor Matz-Lück and Professor Tietje for the invitation. It is always a pleasure and an honor to be in Hamburg. So for the sake of brevity, I shall first state my assumptions before then going on to clarify them. The Common Heritage Principle had and still has for objective to develop a guiding principle to establish a regime benefiting humankind rather than individual states or interests. This obligation to cooperate surpasses that required by general international law. It introduces a revolutionary new positive element into the law of the sea by indicating that the control and management of the deep seabed is vested in mankind as a whole. Those state parties are meant to act as a kind of trustee on behalf of mankind as a whole. The Common Heritage Principle constitutes the basis of the International Seabed Authority. The authority's organization is based thereupon. Both its legislative as well as its executive functions are designed according to the Common Heritage Principle. The formulation of Article 136 of UNCLOS makes it clear that the Common Heritage Principle is a valid erga omnes and enforceable vis-à-vis all states. Yet so far the Common Heritage Principle has not played a significant role in international jurisprudence. One important aspect of this principle is that it can be implemented and enforced via judicial decisions. As far as the deep seabed regime is concerned, the various aspects of the Common Heritage Principle, such as non-appropriation, common interest, equal participation in the activities, equality in rights, intergenerational equity, have been realized in an act of international norm-making via Part 11 of UNCLOS, Annex 3 and 4, and the rules and regulation of the International Seabed Authority, including the Model Mining Code. Thus, for instance, Regulation 2 of the Draft Mining Code indicates which additional considerations are to be derived from the Common Heritage Principle. They cover the whole exploitation and production process, from recovery of the resources to the marketing of the minerals. So to provide an answer here before this round table, it would seem that we should first distinguish between the various disputes. The relevance of the Common Heritage Principle will be most significant as far as deep seabed mining is concerned. Most relevant in this respect is the Seabed Dispute Chamber, according to Annex 5, as we heard today, Article 14, and more relevant, Part 11 of UNCLOS, Section 5, and we have Article 186 to Article 191. In this context, it is highly relevant to consider Article 189 of UNCLOS. This norm ensures that, as far as the interpretation and application of the Common Heritage Principle is concerned, the International Seabed Authority remains the dominant authority. The Seabed Dispute Chamber is limited in its role, specifically in relation to the progressive development of norms rooted in the Common Heritage Principle. However, if a regulation or a rule is criticized for violating the Common Heritage Principle, the Seabed Dispute Chamber becomes involved. This means it plays a significant role at the executive and administrative level in matters of implementation, but does not participate in the legislative process of the International Seabed Authority. The functions of the Seabed Dispute Chamber do not embrace all possible disputes concerning the application of the Common Heritage Principle. The relevant provisions of Part 11 of the Convention that set out the jurisdiction of the Seabed Dispute Chamber are relatively short. While they give the Chamber extensive, in some respect exclusive, but not exhaustive jurisdiction over a wide range of potential disputes that might arise from activities in the area, they also reveal certain gaps. For instance, the weakest point seems to be Article 142 of UNCLOS. Article 142 only refers to risks originating from the activities in the area for a neighboring coastal state, not, however, to risks originating from activities in the seabed of the coastal state neighboring the area. The common heritage principle here seems to have to give way to the interest of the coastal state. For example, let's say acts or omission by the coastal state that have allegedly caused environmental damage in the area, such as transboundary pollution, where sediment discharges in the course of seabed mining travel to the area. These cases are neither covered substantially nor procedurally by Article 142. The second example that does not fall under the jurisdiction of the Seabed Dispute Chamber is the implementation of Article 140 on the equitable sharing of financial and other benefits. Article 160, paragraph 2 FI, or 1, small 1, states that the Assembly shall consider the rules, regulation, and procedures on the equitable sharing of benefit. The conflicts under this paragraph between the Council and the Assembly do not seem to come under the jurisdiction of the Seabed Dispute Chamber. Such a dispute would have to be decided by ITLOS or arbitration, maybe also the ICJ. So the common heritage principle could be invoked as a guiding standard as to whether the relevant rules and regulations meet the demands of the common heritage principle. My assumption is that all state parties have the right, possibly the obligation to uphold the common heritage principle, as reflected here in Article 48 of the International Law Commission's rules on state responsibility. So what are some of the conclusions and implications we can draw from this brief discussion? The common heritage principle, having an erga omnes status, constitutes a legally binding principle. Article 187 of UNCLOS does not cover the whole scope of the common heritage principle. The loopholes will have to be covered by states and not only state parties. Their right to do so or their standing rests in Article 48, paragraph 1A and B of the International Law Commission's rules on state responsibility. The essential question is then whether the common heritage principle can be invoked to legitimize the standing of state parties, possibly all states, giving its erga omnes effect. The answer may be affirmative.
Thank you so much. So I suppose that we will have to talk, or we'll talk a bit about public interest litigation as well, now mentioning the articles on state responsibility and erga omnes effect of norms. Bart, you only had a very brief pause between your own panel and this panel discussion. Do you still see any relevance in the common heritage of humankind principle in litigation?
I do, and I hope that you'll indulge me a personal story about my relationship with the common heritage of mankind. So as a second-year law student, I took my first class on public international law, and my professor was a fellow that Professor Wolfrum referred to earlier, Louis Sohn, who's probably pronounced Sohn here in Germany, who had, at that time, just the year before, participated in concluding the United Nations Convention on the Law of the Sea. And so, naturally, he was very familiar with the topic, and a lot of the class that he taught on public international law focused on the law of the sea. And the paper that I wrote for that class was actually on the common heritage of mankind. And I frankly don't remember exactly what my conclusions were in that paper at this point in time. If you do the math, that was over 40 years ago. But What I do remember is being struck by the beauty of the idea. It is a beautiful legal concept that something that is an important part of the world, that represents a significant percentage of all of the surface of the earth, is the common heritage of humankind. And it was one of the things that that prompted me to want to become a public international lawyer and to work in the field. And I must say that in the years since, I did not think about it very much. But in preparing for this excellent conference, I picked up the subject again. And what struck me is how familiar it sounded, not from my experience in law school, but because in the intervening years, I have done a number of disputes as a disputes lawyer dealing with extraction of natural resources. And having done that, looking at these concepts, the concept of resources being the common heritage of mankind is analogous to that which you find in many national constitutions of subsoil resources being the property of the people. And it's only when the resources that are extracted that they can become a good that the state has the possibility of disposing of. And you can see a similar sort of distinction in the convention between resources and minerals. So they're resources and they belong to all of mankind when they're still down there. But as soon as minerals are extracted, then it becomes a good that the authority can enter into agreements to dispose of. And like the state is supposed to in entering agreements with regard to disposing of minerals that are extracted from the subsoil in national constitutions, the proceeds are supposed to benefit the people of a given country. And so to my mind, there's an analogy there where the proceeds of this extraction of resources from the seabed is to benefit all of mankind in the same way that doing so for a given country is supposed to benefit the people. It also seems to me that there's an analogy between the common scenario where you have a state-owned oil company or mineral company that participates as part of a joint venture or a consortium with a carried interest. So in other words, it doesn't actually have to pay any kind of investment itself, but simply as a condition of the commercial partners being able to extract resources, that state-owned company gets a share of the profits. That seems to me to be analogous in some respects to the concept of the enterprise in this scenario. So it all seems kind of familiar to me now, but at the same time, it is expressed in a multilateral public international law instrument, and it is not at all clear that this is the way that things will be interpreted going forward because of the differences in experience of the people who will be doing it. So that's my perspective.
Thank you very much, Bart. And when you talked about the differences between the resources on the one hand that belong to the common heritage and then the minerals once they're extracted, what then always strikes me when we think about that regime is how different we treat fisheries, so living resources on the high seas, from the minerals in the ground. But it's not a fisheries workshop. So, Carsten, turning over to you, I wondered, it's two questions, I'm afraid, but I wondered what role the Common Heritage plays in the discussions in the Legal and Technical Commission, and on the other hand, from your experience as being a part of the responsible national or German agency, who's also the contractor, how you deal with that principle. Does it play a role? Is it relevant to your different capacities?
Good question. Maybe not in our daily work, but in general, yes. So I'm working at the Geological Survey, BGR. Bundesanstalt für Geowissenschaften und Rohstoffe, which is subordinate to the Ministry of Economy. So in a way we are a state-owned company, not a company authority or governmental contractor, let's say. And yeah, maybe I can spend a few words on the perspective from a contractual perspective. So the Common Heritage of Mankind, as I understand it, simply says that the seabed does not belong to any state, any person or so, but it belongs to humankind in total. And the minerals that are down there on the seabed can only be extracted, exploited through contractors. That's the only possibility. So contractors in a way are an integral part of the common heritage of mankind. Without contractors there's no access to these minerals, I would say. And the process to get there is formalized, so any activities, exploration, exploitation require a plan of work that has to be submitted, an application to the Seabed Authority. And after a review by the Legal and Technical Commission and final maybe agreement, so in all cases there was agreement, or not in all cases, in almost all cases except for one, ends up with a formal contract between the Seabed Authority and the contractor. And so currently we have 31 contracts. One was from the Brazilian company was terminated, but 30 are active at the moment. Most contractors are governmental contractors, such as BGR, and 8 of them, if I'm not mistaken, are private contractors, and there are fundamental differences between these two kind of contractors. So state-owned companies or governmental contractors have a long-term perspective. They have obtained a contract for strategic reasons of the countries, so security and supply, or secure supply of mineral resources, of metals for long-term, for their industries, for their countries. And private contractors, they want to make profit, of course. A company that is not making profit, that is losing money, is a bad company and will go bankrupt eventually. For states, that is different. So the interests between these two kind of contractors are different, and private contractors have a more short-term perspective. And then there are the developing countries. Some of them, South Pacific Island states, African countries, have a strong interest in to do the next step to exploitation, yeah, because the developing countries especially should benefit from the profit that is distributed from the minerals that are exploited. And UNCLOS and the agreement, Part 11 and the agreement, they try to reach or seeking for a balance between the interest of contractors, private contractors and states, and also need to or seek for a balance between exploitation and environmental considerations, yeah, environmental protection of the seabed. So it's a quite delicate balance and not easy to achieve, but especially the council, and I think also the LTC is working hard on this. So one point is interesting for me, so I would like to ask a question. There is an Article 13(1) in the Annex 3 of this UNCLOS, which explicitly asked that the ISA shall, not just may or can or could, it shall attract investments and in technology. And I wonder how the ISA can do this, attract investments without kind of protecting it. So what I understood so far is that it's difficult or it's unclear whether investments of especially private contractors are being protected in some way.
Thank you. I'm just the moderator, so I will not answer the question, of course. That's my privilege tonight. The question I would like to ask all of you is really what I've touched upon a second ago, the question of public interest litigation and who could actually bring claims for violation of the common heritage of humankind principle. But then again, we would maybe, I would like you to elaborate a bit further of what it really is, because from what I read in the convention, it could well be a protection principle. It's preserving the area and its resources for everyone. And that's with the states now calling for a moratorium or precautionary prose are framing it a bit that way. The way I read it, I haven't been present when it was drafted, but the way I read it, it's an exploitation principle. The resources belong to all to be exploited and then for everyone to benefit. I would, from my personal perspective, like to see more environmental protection in there, and there, Rüdiger, we too disagree on whether a moratorium or precautionary pause is a good thing. But I see it more as a kind of exploitation principle. And so for public interest litigation, that could mean different things. It could mean that people, or states rather, initiate disputes for more protection or for access. It's not a proper question, it's a comment, but still I'd like your views on that. Any views? I know.
I would like to say the following. First and foremost, the Common Heritage Principle provides for the distribution of benefits to a certain group of states, mostly. And this is also an element of the Common Heritage Principle. What you said, it is also an element of the Common Heritage Principle to ensure that these resources are protected, used in a sustainable way. Therefore, you may have two, so to speak, internal conflicts. Nature, it's not so much climate change, although it also comes in, but let's say nature on the one side, and the development of developing countries. Such conflicts do occur, and they cannot be solved only for one side or the other. And this is a reason why I'm critical about this moratorium. The moratorium, or the draft model code, provides for further research. Think about the reserved areas, the comparison with areas where resource activities will be undertaken and others where this will not be happening. But I will tell you that my criticism has a personal background. This situation I faced once already, namely CRAMRA, the Convention on the Development of Mineral Resources from Antarctica. It has a perfect, let me put it this way, regime on the protection of the environment. Nobody denied that. But then for sovereignty reasons and on the backing of Greenpeace, the treaty was not ratified. Okay, that happens. And now we are speaking about mineral resource activities in Antarctica, and there are lots of mineral resources, without the very intensive regime protecting the Antarctic environment. Therefore, occasionally, it is wise to establish a regime before activities start. And in Antarctica, now they will be starting, and now the protective regime will be limited, much more limited than ever before. And I hear that the same will be happening for the deep seabed. Let me finish at that for not to making me unpopular.
Yes, indeed, since public international law and environmental law in particular is usually reactive to accidents, and we don't need to talk about oil pollution, but it's usually reactive, and indeed the proceedings for seabed mining were seen as a more or less unique process where you were supposed to have the rules in place before an activity are started, but that seems in danger now.
Maybe a few words on the moratorium. I completely agree with you. It is not an international moratorium. Instead, there are several national moratoria. So Germany has asked for a precautionary pause. Others have called it moratorium. France even a ban of deep sea mining. But all of them are only valid for the nationals. For BGR, for example, would be valid, but not for the companies from Nauru, for example. Yeah. An international moratorium would need to be dedicated by or installed by the International Seabed Authority, and must be in agreement with all states. And I don't see this would come, never.
Sorry for interrupting you.
Yes?
What is then the effect of this limited moratorium? Does it make a difference whether Germany and the Netherlands, who are very much in favor of the moratorium, don't do deep seabed mining, whereas China does?
That's correct. That's a problem with this kind of moratorium, and so it's only binding for a few nationals, for a few contractors, but not for all of them. For China, it is not, for example. And a moratorium could make sense if the reason for it is that people want to understand better the environment, which requires a lot of money, because exploration or scientific research in the high seas is very expensive. And I don't see this coming. The money spent for investigating the environment came from the contractors. So the latest numbers I've read is that they spent 2.5 billion in total and something like 350 millions in environmental research during the first contracts were concluded in 2001. So I don't see governmental money spent for investigating the environment. There is a little bit from Europe, for example. There is a project, Mining Impact, it's called, sponsored by the national funding agencies. But besides this, I don't see any more dedication for research on the environment. That's a problem, or one of the problems with the moratorium. And there may be legal problems as well.
James, you were starting to respond to my comment a while ago. Do you still want to?
I'm thinking no.
No.
So from a disputes lawyer's perspective, the question of public interest litigation gives rise to the preliminary question, where would it be brought and by whom? The international forums, private individuals don't have standing unless they're contractors. And I don't think it would be the contractors that would be bringing that litigation. And so the question would be, where would it be brought?
Or if states bring it?
States could bring it, for sure. There's no question about that. And there is a history of states bringing cases that are of general interest in the world to international fora. So that is possible. And there are a number of small states that are very focused on environmental issues, for example. So that could happen. It's litigation in the public interest, but it's not litigation brought by the public, if you see what I'm saying.
True. That's true. And Nele, you said that standing would be brought by the Articles of State Responsibility. Could be. You want to elaborate further? No. could be one issue. I mean, the issue of public interest litigation at the moment at the ICJ is a huge topic, and the question how the Articles on State Responsibility fit in there and who has standing for what reasons is highly debated. You look like
so. Just one other angle on the public. So obviously there's the standing to bring the claim, but also there's other forms of participation if a claim is brought. And if we are genuinely talking about the common heritage of humankind, who's to say states should be the only participants? Could we see relaxed rules on amicus curiae, for example? You know, ITLOS has been relatively reluctant so far to formally accept those, at least. But can you justify that if you're talking about a common heritage regime? It's less clear. And one example I can think of very recently is the UK EU arbitration on fisheries, where they have there has been NGO interest in amicus submissions on those environmental issues. Whether they were formally accepted, I'm not sure, but certainly there were attempts to put in those briefs. So, you know, there are other ways of broadening participation once you've got litigation ongoing.
Anyway, I wanted to open up to your questions as well and give the... But I don't think if there's... I don't know whether there's still anyone on YouTube watching, but they could hear you better.
Thank you. Bring it back. Going back to this limited moratorium, let's look upon it from the national law of Germany. The operators which are engaged in the Clipper zone or in the Indian Ocean from Germany would be limited in their activities, right? They will argue, I'm not going to represent them, that this is unproportional. If everybody stops deep seabed mining, then it has an effect. If only Germany, Netherlands, etc., it has no effect. What is then the justification to interfere with the property rights of whomsoever from Germany or the Netherlands? Let me tell you, I used to be a judge in the German administrative courts. I can tell you, there's no chance in a German administrative courts that only if the restriction imposed about German or Dutch or might be French, while the Chinese, Russians, etc. could continue. They will also point to the wonderful environmental record of China as described in the arbitration on the South China Sea. Remember what is being said there?
Excuse me again, please.
Have you read what is being said in this very long judgment? Arbitral award about what is being happening environmentally if one allows the Chinese to continue, that is particularly the harvesting of the so-called big clams, where they go with a rotator into the coral reefs and then have the big clams. And an expert here from Germany, from the Max-Planck, no, it's not a Max-Planck, Institute on Tropical Seas, testified that it will take 10,000 years before the corals will revive. Yeah.
good statement. Well, in the case of Germany and the precautionary pause, the BGR is not a private contractor, but it's a authority subordinate to the Ministry of Economy, who has released this precautionary pause. So I would say it doesn't have an effect on BGR, on our work, because BGR would, the Geological Survey, would not do exploitation. The idea in 2004, when BGR was asked to apply for a license or a contract, was that at a certain stage a private contractor would step in and take over. That has happened. It has not happened so far, and with a precautionary pause it will not happen, of course, and that was the idea, I think, to prevent private investors to show interest in or take over the license that has been brought forward by BGR within the 20 or 18 years now. Yeah. What can I say more? I don't have a legal advice for you, as you can imagine.
I know. Just raising problems.
I see 3 hands in the auditorium, one over there, one in the middle, and one further up. Maybe in all 3, one after the other, and then I ask you.
Yeah, thank you very much, Carsten Nofroth from the University of Hamburg. I'm wondering whether this common heritage principle in the present context might also have a temporal dimension that might be enforced by state-sponsored public interest litigation, in the sense that heritage, common heritage, of course, also involves, you mentioned already, intergenerational equity in that regard. The idea that, of course, exploitation should be possible, and we have discussed now amply the respective tensions related to environmental protection in that regard. But what about the rights of future generations in that regard? Should the, once deep seabed mining becomes technically possible, which is surely very soon, already at present the case, and also commercially feasible, the question comes up whether all exploitation actually should take place within the time frame of the present 1 or 2 generations, or whether a certain amount of the resources should be preserved, not for the sake of preserving it, in the sense of preserving nature, but in the sense of being subject to exploitation by future generations who might economically benefit from it. I know it's a very complex question, because ultimately you can also say, if currently countries from the global south are in particular benefiting from the profits that are generated now, that will indirectly also benefit future generations being born and growing up in countries in the global south, because they are potentially better off if their countries are economically better off. But nevertheless, I was wondering whether this could be a potential dimension of this public interest litigation based on the principle of the common heritage of mankind. Thank you.
Thank you. I would like to collect.
Yeah, thank you very much. I had 2 questions. One was exactly on intergenerational equity. I was in December at the UN headquarters in Bonn. It was a conference on space sustainability. And the common heritage of mankind is also found in the Moon Treaty, that Moon and its natural resources are the common heritage. So it seems to be a language that we find commonly in global areas or areas beyond national jurisdiction. And there was again this idea of why not say and decide to save some of the resources for future generation. And we heard before that there is not so much dedication on investigating or researching the effects of the environment, but what if deep sea mining activities have an irreversible effect on the marine environment? So that was my first comment question. And the second one, I'm really intrigued on this public interest litigation. So if I understood correctly, is there an agreement among the panel that the unclosed dispute settlement allows for an, let's say, actio popularis, or like enforcing community interests? And do you see any challenges or procedural hurdles with that? Thank you.
Thank you. And the third question, and then you will have to wait, Robert, for the next round of questions. It's late, so I don't want to overwhelm them.
Anna Groß from the German NGO Deep Wave. As if I'm correctly informed, the seabed authority has also the duty to protect the seabed on behalf of humankind as a whole. I didn't hear anything about this.
Who would like to start? So we have three questions, one on future generations and future economic benefit, the second on intergenerational equity and our relation to other, like the Moon Treaty, but also on enforcement community interests, and the element that has not been discussed in any depth, the protective element for the ISA. Bart.
So on the intergenerational element, question. I guess the one thing that I've read, I'm not an expert by any means, but according to the Seabed Authority, as of December 2024, 0.0089% of the area had been explored. And so it seems, given how little of the deep seabed has been explored, that it's pretty unlikely that within the next few generations, the entire seabed will be exploited, but that's just an uneducated guess.
Yeah, that's a good explanation. Maybe I can expand a little bit on this. I don't have a legal answer. From an ethical viewpoint, I would say yes, of course. And from a geological viewpoint, I could say it shouldn't be a problem, as you just mentioned. The Clarion-Clipperton zone, where most of the contracts are currently, has a size of roughly 5 million square kilometers, which is about the size of the European Union, including the UK, when it was a member. And deep sea mining could, within 1 year, clear or mine a field of 200, 250 square kilometers, one company with one collector. So I think 1/3 is protected of the Clarion-Clipperton zone, and 1/3 is covered by exploration contracts, and the rest was reserved areas. But if you just would mine 20% of the exploration contract areas, I once calculated it, I can't do it without my computer, to be honest. I think it was something like 5,000 years it would take for one company. So if there are several companies, and there could not be hundreds, that would be impossible, because the metal prices would go down then. Let's assume 5 or so, it would take still 1,000 years to to mine the entire 20% of each of the exploration contracts. And you have to keep in mind that this is just one part of the world ocean where manganese or polymetallic nodules occur. There's the Cook Islands, EEZ, and there are several other very large areas in the Pacific, Atlantic, Indian Oceans where nodules occur which have just not been explored. So I wouldn't be too concerned regarding what is it called? Intergenerational, this is a problem about this. Yeah.
I wanted to come back on the environmental question because I mentioned the duty in my opening remarks, and for me it's a very important one. I think there are different ways in which that feeds into the work of the ISA. There is this big debate about whether mining should take place at all. We've been there, and I won't contribute on that. But when it is authorized, both through exploration and potentially exploitation, there is a need to integrate environmental considerations, do environmental impact assessment, and minimize threats as far as possible. So that's one element of the environmental work. But I think an equally important one is the protected areas. The ISA has designated a number of areas in the Clarion-Clipperton zone, I think 13 to date, which it has said there will be no mining there, and it's working on doing that in the other areas. And that could be considered part of its duty to protect these areas on behalf of the international community. I would just add to that the importance of the agreement on biodiversity beyond national jurisdiction, because that will require the ISA to then collaborate and coordinate with other intergovernmental organizations working in areas beyond national jurisdiction and ensure we have a coherent network of marine protected areas in the area and on the high seas. And that's just as important. In a sense, it's not formally reflected as the common heritage of humankind in that instrument, but it's the same ethos that we do need to conserve the oceans from all activities on behalf of us all, and that work is ongoing, and the BBNJ agreement will be an important part of that once it comes into force, hopefully.
Would you like to comment on the?
It seems that article on the intergenerational equity aspect of the common heritage principle, it seems that Article 151 on the production policies is the most relevant article in this regard, but it is so long, I think it's the longest of UNCLOS, so if I may refer to Professor Wolfrum for explanation.
Give him the mic. Just giving mics away.
I spent my days at the Law of the Sea Conference exclusively for Article 151 in a very, very small negotiation group under Satyananda. Please do consider that one mining field for polymetallic nodules has a significant size, and as far as cobalt is concerned, would produce roughly 100% of the world consumption of cobalt. That means if you open a second field, that would mean that the cobalt price and the commodity market on cobalt would collapse. We must take into consideration that has been agreed and has been fixed, that considering the world commodity market, it is important that deep seabed mining is phased in slowly, very slowly. And I would be very astonished if there were more than 2 fields on polymetallic nodules, and perhaps not even on an additional field on polymetallic resources. Therefore, let's not assume that there will be a rush, a huge undertaking that would be objected to, and the history of Article 151. I confess to what Naya just said. The provision is hard to understand.
Yes.
And if you would ask me what does it mean, I can give you a rough indication what it means, but how it concretely works is rather complicated. Actually, it's more a question for Mr. Tietje, for he's dealing with these issues. There's no documents from this committee, zero, not even in my private property, for Satyananda saw to it that all his suggestions were taken back. Therefore, you can only rely on the text. Nice exercise for interpretation.
Thank you. We still have a few minutes. I do realize that this panel is between you and the drinks and snacks, but there are 2 more questions I would like to take and have the panel answer. And then it's a very brief farewell from my side and a few remarks on a potential publication. But first, the questions, Robert.
Thank you.
The concept of the common heritage of humankind is a very important, significant development in international law. It took place over quite a period of time, and it has a number of applications, Moon Treaty and the area. The discussion around it, though, properly needs to be mindful of the difference between lex lata and lex ferenda, law as it is and law as we would like it to be. Right? So the concept of the common heritage of humankind was adopted by states because states are the actors in international law. And states set up the UNCLOS Convention and signed the UNCLOS Convention and set up the dispute resolution provisions that we are discussing and made certain exceptions to allow non-state actors in very specific prescribed circumstances to participate in that dispute resolution regime. The decision about what constitutes an heritage of humankind and how it gets exploited and when it gets exploited is decided by states. That's the way the law is. That's the way our international community is. If we don't like it, if we imagine a way it should be, so that, for example, things like whether there should be a moratorium or what time period in which seabed resources should be controlled, if we conceive of a universe where it's decided by you and people who think like you, well, that's fantastic, but that's not the universe in which we live. We live in a universe where there's formal equality between states. And if you personally don't like how this has been structured, well, you can complain against your government and try and convince your state to act in a different way. And you can try and convince other states to act in a different way. Just because you, in Germany, have amongst the wealthiest countries in the world, and you live nicely, and you have lots to eat, and you think you'd like everyone else not to go after seabed resources because you don't like it, there's a number of ways legally and in the universe in which we live, you can go about doing this. So, for example, you could elect, you're having elections right now, you could elect a government whose priority is to take 90% of the annual GNP of Germany and transfer it to countries that will vote to suspend development of the common heritage of humankind. And I'm sure you could get quite a number of states to go along and vote with you if you guarantee you'll give them 90% of your income every year. You could probably get quite a few states on board. I think if you looked into your hearts and thought, would I be willing to live a life that was 90% less standard of living than I have now? I'd still have a house, I still have enough to eat, but I wouldn't have the lovely computer this woman has to my left, or the iPhone. I wouldn't have lovely colored sweaters and a piano behind the stage. I would imagine that there's probably not so many people in Germany who'd be willing to do that. But that's the universe in which we live. Right? Just because you like something and you think it would be good for the world doesn't necessarily mean that in international relations that's what enough countries to change the way the ISA and the rules and regulations have been set up have to follow what you personally think is a good idea. So if you want to affect this kind of change to reflect things that you personally like, you have to think, how can you actually do it? Having demonstrations in downtown Hamburg won't really do it. Trying to convince other countries to vote the way you would like in the ISA, that might work, but then what do you have to do? They want development because they get money. Okay, give them money not to do it. Governments do this sort of thing all the time, but I suspect the price is just a little bit too much. But that's the reality in the universe in which we live, and you've got to think about common heritage of humankind in that way. It's humankind, not those of us who are nice and sitting in this lovely warm room right now.
So Rod followed my example of not asking a question, but giving a comment. Well, we have another question or comment from Christian Tietje, and then the last round of the panel.
Very briefly, certainly not an interpretation of 151, but just on, because Carsten Rühlemann asked, do we have investment under Article 13(1)b of Annex 3? I think that's highly relevant and comes a little bit back to the beginning of our conference. From my perspective, we of course have investment as such. The question is only whether it's protected. It's not protected under international investment protection law towards the authority, because we do not have any treatment standards that are written down. We do have some, let's say, on good administrative practice rules maybe that are applicable, but not in a strict sense of treatment standards under international investment law. That's a bit different with regard to the relationship between investor, contractor, and sponsoring state. In this regard, we could have protection, but only if we have a foreign investor as a shareholder, because the possible contractor needs to be incorporated as such. So between the incorporated investor and the home state, there is no investment protection, with the exception of human rights, Article 1 of the first edition protocol of the European Human Rights Convention. But as we need a foreigner in order to have a bilateral investment treaty, or maybe the Energy Charter Treaty be applicable, we need some more tricks, so to speak, in order to have protection there, or for the specialists among us under Article 25 of Exit Convention. But so overall, it's not a classical situation of investment protection, even though we do have investment. Yes.
Any more comments from the panel? I see more hands, but I will not allow more questions. So just a last round of the panel, if you wish to comment, answer. I see shaking face. Yes.
Maybe one word regarding your intervention on the destruction of the seabed. So NGOs often say the seafloor after being mined is destroyed, which is a word I don't like. So if I take this glass, like
or your glasses,
my glasses, and drop it, and it breaks, then thank you. Then it may be destroyed. I can never use it again. But for the seafloor, it's different. The seafloor is different than it has been before. The nodules, or part of the nodules at least, are taken off. But it is recolonized, and that happens more or less immediately. But the living community that comes back is different from the one that has been there before. But it's not that it's a dead area, that you leave a dead area after mining. That's not true. We already know this, but we don't know details. For the details, we need tests. And one test has been carried out in the Belgian, or in the area of GSR from Belgium, and in the area of the BGR in 2021. And we are currently compiling the results, especially the biologists, which is the most important, or a very important part, because we are all concerned about the fauna that's living there. If it would be dead, we would not be concerned, but it is not. There are animals living there, most of them very small, 99.9% are microscopic, and there are only a few big animals. But these animals, or part of them at least, come back. That is confirmed by tests that have been carried out decades ago already, and have been sites that have been revisited. Yeah, so I just want to make the point that the word destroyed is not proper in this, in this context.
Okay, thank you. So I think the panel deserves a warm round of applause. Thank you all so much, and I will change places for a formal farewell. So, thank God I've never planned to give concluding remarks in the sense that I will try to summarize all the brilliant panels. So I never intended to do that, but even if so, I would now say it's about time to go and have drinks. So it's my honor, my privilege to thank everyone who made this event possible. That's most of all our speakers who came here today, even sitting in two panels, some of them. So speakers who traveled here, some of them who had to leave already, who made room in their calendars, which I'm sure are really well filled already, to spend a Friday afternoon and evening in Hamburg. So thanks to our speakers, thanks to the audience, because we're doing this not for ourselves, not alone for ourselves, but also for you. Thank you for being engaged in the discussions, for asking questions. Thanks for the initiators. I came on board a bit later with Richard Happ and Christian Tietje, so thank you for having the idea, for having this forward, putting this forward. And of course, for those who've sponsored and financed the event, because as you all know, it wouldn't have been possible without some money in the background. So thank you all very much. And for those who intend to publish what they have said here in some form, I would like to give the floor very briefly again to Rüdiger Wolfrum, who has an idea where this could be published.